Any mention?
Lordship, I beg to mention item number 17, 18 and 22. The learned counsel is out of station on urgent personal difficulties. So let the matter come after 2 weeks.
Your Lordship, item 18.
17?
17, 18 and 22.
Your Lordship, I am appearing for item 18.
Yes.
Your Lordship wanted one of the appointment letter to be placed on record. I have already filed the affidavit.
When was the affidavit
matter
filed?
was already heard. And 2 appointment letters I have filed and whose names are included in the list at page 24.
You filed that?
I have filed it. It is on record. So
He's not here, what to
nothing
do?
left out further, Your Lordship.
Listen, you see. At least you have to perform final rites, huh? Even there is nothing left. So, 17?
17, 18 and 22.
1822, yes. Right. After 1 week.
18 then after 2 weeks because next week I am busy.
After 2 weeks, Your Lordship.
2 weeks?
18 after 2 weeks.
2 weeks.
Much obliged.
May please, Lordship. I beg to mention item number 16, Lordship.
For upgrading?
Lordship.
For hearing?
Lordship.
Why? Why you want adjournment?
We'll do it today. I'm not ready, Lordship.
That's regarding the acquisition matter?
Acquisition matter. Only last time there's only some mistake in pagination that I have corrected.
Okay, 1 week, yes.
Lordship. Much pleasure, Lordship.
May I please, Your Lordship? I beg to mention item number 23, Your Lordship. I pray for 2 weeks' time, Your Lordship.
And who's the other side? You inform them?
Yes, Your Lordship.
You inform
I
them?
inform them, Your Lordship.
Who's up on the other side? Harlingdo Kibarsaji, he is. You're sitting there, no objection?
No, I didn't hear.
Yes.
So, Lordship, we have objection regarding.
Adjournment?
Yeah, objection
They have
regarding.
adjournment. They have objection. What are you going to do? Who is the senior?
He's on another courtroom, Your Lordship.
You want to do it today?
At the rate at the end of the boot.
What's the matter about?
This is a matter pertaining the teachers in the school. So this teacher will remain absent
Because
from.
they have objections. Yes.
This Lordship, I beg to mention item number 25. Objection, Lordship.
25? Okay, 2 weeks, yes.
Lordship. Much obliged, Lordship.
Supplementary list, item number 1.
Well, the petitioner is a 65 years old gentleman, my lord, who has also previously approached this honourable court regarding his date of retirement. My lord, here what happened, he has retired 6 years back, my lord. But till now, my lord, his pension papers has not been settled. AG has written many times, my lord, to the concerned.
Why 6 years back retired? It's not been, last pay certificate's not there.
Sorry, my lord.
What's the problem?
They are not giving the clarification which was asked by the AG. It is the Deputy Commissioner, North Garo Hills, election, my lord, should have given the clarification. There are 6 or 5 letters which has been communicated by the AG to give the clarification. But
Which clarification regarding what?
Pension, my lord.
No, there has to be some issue if which have been granted.
My lord, if my lord may kindly see.
Last pay certificate.
Last pay certificate, my lord, may I kindly see Annexure 7, my lord. Page 44, my lord.
Yes.
My lord, may I kindly see, these are the 4 requirements which was.
This letter is dated?
Letter dated 25/10/2012. Yes, my lord.
Yes.
So this is the letter, my lord, by which certain clarification was sought from by the Deputy Commissioner, my lord. Till date, my lord, they are not giving, my lord.
Yes, what is this? I'm 18th retired.
We seek instructions why they have not been able to give the
What
clarification sought for.
about Accountant General?
Lordship, here, paragraph number 13 is very clear. There are 3-4 points which the documents were sent to us. But then we sought clarification and actually we've sent 5 reminders also, Your Lordship.
Para?
Para 13 of their petition, it's clearly
Page
mentioned
19, my
there.
lord.
Page 19.
Yes.
So after that, Lordship, after we have sent back the papers to the office concerned, the department concerned, and we have written as many as 5 reminders, which was not again disposed of or not replied to.
No, you take down heard Mr. SDNL counsel of the petitioner issue notice MS EAG with so and so is present on behalf of the respondents number
126 and 10, Your Lord.
126 and 10 and 126 and 10.
Yes,
10 is the Treasury Officer, Your Lordship.
126 and 10. What about this? Okay.
AG is
126 and
represented
10?
now.
789, Your Lordship.
Or 2.
Oh, you'll be
Oh, you
appearing
think
the
that
number
also?
2.
MSTI is present on behalf of respondent number 1, 3, 4, 5, 6
and 10, Your Lord.
and 10. Mr. P. N. Nongri for 2 and Mr. K. Kamal Phulang.
7, 8 and 9, Your
Sorry,
Lordship.
as such, no further notice required. Stop. Next paragraph. It is noted the matter concerns release of pension of the petitioner, who stated to have retired since 2018. Yes, however, till date due has not been afforded the same. Stop. It has been submitted also that at para 13 thereof of the petition, that the respondents 7, 8 and 9 have repeatedly asked for certain particulars to be furnished by the respondent number.
Respondent number 6, my lord.
Respondent number 6, as to respondent number 6, which it is stated has not been forthcoming. Stop. This is matter after 2 weeks expected the next date. Positive instructions will be forthcoming. Yes.
Ma'am, hello.
Obliged.
Much obliged. Item
Pension
number
matter
2.
you can't keep like that.
Yes, Lordship. Here, this is the petitioner. Here is the President and Secretary of all Garo Hills Archery Association, Tura. Now, might often this association
They
was.
have tier in Tura also.
Lordship.
They shoot the tier also.
Lordship. Yeah, they have.
Like Shillong only.
Like Shillong only.
Or they take numbers from Shillong.
No, they take it. No, they have their association. They were given particular that
They shoot every day.
No, not selling those tickets only. Not,
From the numbers, where do you get numbers from?
we get it from Tura only.
No, who shoots the tier?
No, shooting is here. No shooting. Shooting is here in Shillong.
In Shillong. So numbers,
Yes.
and the same numbers
Yes.
run in Tura also.
Yes.
Okay.
Now, whatever this is the register. We have
Who is
registered.
this? Who is this association?
Yes, registered in the year of 2017, and then after that, after 3 years, we are asked to renew the license, and we have been renewing. In the year of 2021, we have renewed the registration, and there is one of the member have got some involvement in police case, but the police verification.
Involvement in what case?
In the police Tira PS case, some case was there against one of the member, and then police verification found nothing against the member of the association, but only there is indicated there is some involvement in the one of the member is involved. However, they have in the year 2021 they have allowed
When
the
they
same.
gave police verification, they said you involved in the case.
In that is in the case, but however they allow to renew in the year of 2021, and that another term expired in the year of 2003. We are supposed to renew again. We have approached for renewal. Again, we went for the police verification, and the same in the case. Police say that there is involvement, but nothing adverse, no adverse remark against the petitioner. And in the year of 2001, they have allowed, but in the year 2003, they are saying because one particular person is involved in the case, that is the reason they don't allow us to renew. But the section 28 of the Society Registration Act very clear. I have mentioned in the petition also. It is said that only unless the person is convicted. Unless the person is convicted. And moreover, in the year of 2000 for the same case, they have allowed, but only in 2023.
So in the preceding registration when it was done, it was also reflected that you were involved in the case.
Is there?
Registration was done.
Yes, they have. In the impugn order said that
Okay,
because
I heard Mr. P.T. Sangma
Yes,
issue notice. Ms. R. Kohli is present. I notice on behalf of all the respondents.
My lord.
All respondents.
Lordship.
No further notice called for. Just after 3 weeks for affidavit or instruction. Yes.
Highly obliged, my lord.
Item number 3.
Yes.
May I please, Your Lordship? Lordship, in this petition, Lordship, an advertisement was published, Your Lordship, for the post of assistant teacher deficit. Your Lordship, may kindly come to Annexure 1, Lordship, page 24. Annexure 1, Lordship, page 24.
24.
Type copies on page 25, Your Lordship. Maupo, the first Khasi daily newspaper.
It was clear enough. Application standard form for this so-and-so post, so-and-so at UC. Okay. Yes.
Seeing the advertisement, Your Lordship, I have applied for the said post, Your Lordship. And Your Lordship, after the due selection process,
Yes.
I was given the appointment, Your Lordship, by the school managing authority, Your Lordship.
Where's the appointment?
Appointment, Your Lordship, Annexure 13, page 40, Your Lordship.
40. 40.
Yes, Lordship.
Okay.
And the same was approved by the Subdivisional School Education Officer, Your Lordship, in Annexure 12, page 39, Your Lordship.
Okay.
And
Right.
after being appointed, Your Lordship, I have joined the said post from 4th September 2023, Your Lordship, and I've been serving the school, Your Lordship, for a period of 6 months. However, Lordship, on 4th March 2024, the respondent number 6, who is the Church Committee, Lordship, they have issued two letters, Lordship, dated 4/3/2024, which is
Where is that?
at Annexure 19, Your Lordship. Page 62, Lordship. Type copies on page 63. Your Lordship, the Church Committee, Your Lordship, they had directed the school managing committee, Your Lordship, to scrap my
Why?
result, Your Lordship, interview result.
Why? What did he say here? Yes. With
The-
reference, yes.
May I read, Your Lordship?
Yes.
With two so-and-sos subject to scrap the result of the interview for the post of assistant teacher in place of a retired teacher, Mr. So-and-so. Madam, with reference to the subject cited above, we understand we come to let you know that the Church Committee, which was held on the 25th February 2022, has decided to scrap the result of the interview for the post of assistant teacher in the place of a retired teacher, Mr.
Now,
So-and-so.
who issued this one? This church?
The Church Committee, Your Lordship.
They're sponsoring body of the school.
Church Committee, Your Lordship.
Okay, yes. Then what happened after that?
And
You terminated your service.
yes, Lordship.
You've terminated your service or
No,
you're still
not yet,
working?
Lordship. They have not terminated.
Okay, yes.
And Lordship, and in the next page, Lordship, Annexure 20,
Yes.
the Church Committee, they have directed the school managing committee to re-interview, Your Lordship.
Okay.
And they have given 5 days time, Your Lordship, for giving their decision, Your Lordship.
Yes.
Lordship, the action of the Church Committee in issuing these letters, Your Lordship, is clearly illegal, Your Lordship, since the recruitment process have already attained finality, and the impugned letters are not maintainable, Your Lordship.
Yes. Who will accept notice?
I'll accept on behalf of respondents 1, 2, and 3, Your Lordship.
Yes, sir. MS Kharchamlang, Council of Petitioner.
Your Lordship, I have also filed this case, Your Lordship, for staying the
Yes, sir. Issue
impugned
notice
letters, Your Lordship.
returnable in. How many parallel respondents are there?
Three, Your
Returnable in
Lordship.
3 weeks. Issue notice, returnable 3 weeks. MS, the announcement GA accepts notice on behalf of the respondents 1, 2, 3. Petitioner takes step for issue of notice on respondents number 4, 5, and 6, Petitioner 80. Established after 3 weeks for instructions affidavit. I am the case. This case number 37, 2024, in WPC number 50, 2024. This is an application for distinct impugn letters dated 4/3/2024, and as 24 in the connected writ petition, which have been appended as annexures 19 and 20. Stop. Next paragraph has been submitted by the counsel of the petitioner that the petitioner, who was serving as a teacher, had been duly selected by had been selected by due process, and has been serving since
4th September 2023, Your
4th
Lordship.
September 2023 till date. However, it appears, however, she submits by the two impugned letters, the church committee has directed the managing committee of the school
Yes, Your Lordship.
to re-advertise to hold a fresh selection to the said post, which he submits as untenable in view of the fact that she has been duly selected. Yeah, anything to say? No.
Your Lordship, I have no objection to the stay.
Yes, MS seeks time to obtain instructions. Stop. The petitioner has made a prima facie case for interim protection at this stage. Accordingly, the impugned order shall stand suspended, and no coercive action should be taken against the petitioner by the respondents 4, 5, and 6.
Yes, Your Lordship.
5 and 6 in any matter. Yes, after 3 weeks.
Obliged, Your Lordship.
Item number 4.
Lordship, this is the same matter which came up yesterday, Lordship, with regard to the rejection of my...
Why change counsel overnight?
She's not keeping well, Your Lordship.
Yes.
Lordship, I've taken instructions, my Lord. My instructions, my Lord, are in two broad respects. Firstly, my Lord, and this is what petitioner herself has admitted. Petitioner herself is admitting in her petition that the entire selection process for establishment of this retail outlet, it's an online process. It's an online automated process, my Lord. So there is no scope, there is no possibility of accepting or submitting any documents offline, my Lord, in physical mode. Number one, my Lord. Number two, my Lord, the instruction is based on what the submission was advanced before this Honourable Court yesterday. If Lordship recalls, what was submitted yesterday, my Lord, was that she submitted certain documents with us. There were certain documents which were found defective. So she was sent an email on 18th of January for rectification of those documents. According to her contention, she received or she learnt about this on 6th of January. She was required to submit the documents by 8th of February. 6th of February. She was required to submit by 8th of February. So she was well in time.
Yes.
Again, according to her submission, my Lord, on 6th of February, when she attempted to upload the rectified documents, certain technological internet connectivity issues prevented her from uploading the rectified documents. Lordship, it is
but
there.
There's a provision for subsequent to upload subsequently. Also, I mean, it's the system will accept that.
No, this was within time, my Lord. Because the cutoff date was 8th of February. On 6th of February, according to her submission, she found out and she immediately tried to upload the rectified documents on 6th, my Lord. However, her contention is that some technological and internet connectivity issues prevented her from doing so. My Lord, it is here, my Lord, that a slight misdirection has been attempted. And this is borne out by the contents of the writ petition itself. If Lordship kindly looks at para 10 of the writ petition, my Lord.
Yes.
In para 9, my Lord, she has stated that she found out about the 18th January email only on 6th of February, assuming that to be correct also, my Lord. Para 10, that it is pertinent to state that immediately on being aware of such fact, the petitioner made fresh affidavit rectifying the clerical error and the correct Mauser number on the 6th day of February 2024, along with the layout sitemap. However, the petitioner, while trying to upload the aforesaid corrected fresh documents, the same could not be uploaded in the portal as there was no such link for uploading the corrected documents, and the petitioner, having no other alternative and to avoid being disqualified, has resubmitted the previously uploaded documents. So, my Lord, two things come out from here. One, her admission
But
that
she uploaded the defective documents again.
the defective documents again. So number one thing that comes out, my lord, there was no connectivity issue on 6th of February because she uploaded some documents. So there was no connectivity issue, my lord. Second contention, my lord, is according to her, is that there was no link or option for uploading the corrected documents. My lord, this is where the misdirection, my lord, has crept in. If lordship kindly allows me to place for lordship's perusal this sample screenshot of the portal, my lord.
No, but you should have no reason to, to what do you call it, sabotage her own case. Since she's interested applicant.
Absolutely, absolutely.
And so it'd be in the best interest that she uploads
Absolutely,
whatever.
my lord. Absolutely, that's absolutely, my lord. That's exactly our submission before this honourable court. My lord, this is a sample screenshot of another person.
Can upload rectification documents.
Yes, so this is the screenshot of another person's.
Maybe they're not so computer savvy. That,
my lord, if
I
can,
am the same boat also.
My lord, if I can just explain. So, my lord, what happens is when the documents are submitted, they are submitted through this portal, through this page itself. If there are defects, an email is sent, communication is sent to the applicant that kindly upload the corrected documents.
Yes.
Now, once the portal is opened again, there is a clear message on top, my lord, in the middle, if lordship sees.
So tell me one thing, Mr. General, without,
Yes, yes, my lord.
Traveling here and there.
Yes, my lord.
Whether it's just, is there any other reason for not granting her, the concession of being re-examined?
No, my lord. No, my lord. So the
can you do it offline?
I've taken specific instructions on that. It's not possible. We are mandated not to accept anything offline by ministry, my lord. So this portal.
I'll give you my own personal experience to update the KYC details online. I've been struggling with it. It's like that. So what are you going to do?
Lordship, there are. I agree, my lord. There are
challenge this.
Lordship, there are technological limitations. But here, what has happened is, being aware that she has to upload the rectified documents through mistake, through inadvertence, my lord, she uploaded the wrong documents, the unrectified documents. So, my lord, to sum up, my lord, it was a mistake that was committed by her. Consciously.
She was punch the button, you skied in the same thing and would have gone up again.
Consciously, unconsciously, but her submission before this honourable court that there was no link, etc.
No, we can disregard that, but then there's been no reason to doubt as a, her genuineness. I mean, only thing is that some Moser number is incorrect in a notarized affidavit.
Naturally.
And she's annexed the notarized affidavit that has been corrected.
Yes, ma'am.
So then you take a call on it.
Yeah, my lord, what has happened because of this, shall we say, mistake committed by the petitioner, we were not in a position to accept her application. So she was relegated to something called a Group 3. Initially, she was in Group 1. Now she's been sent to Group 3. And Lordship would have noticed yesterday also, if Lordship kindly looks at the second last annexure, that is page 35, my lord.
Page?
35. This is the rejection email, my lord. 35. Annexure 10.
Yes.
This is the rejection email, my lord. Point number 4 on this page, my lord. In view of the above, we regret to inform you that your candidature has been found ineligible. However, your candidature may get considered for selection along with Group 3 applicants as per guidelines. So it is not like she has been completely...
What Group 3?
If I can just explain, my lord, there are 3 groups.
Group 3, that means the chances they become smaller, they dim.
They're dim. I have to be...
What is there? There should be a system for thing offline. Like you're dealing with gargoyles and all.
Lordship,
dealing with somewhere in the metro or something where
Lordship, on a
you don't have people also to help these kind of people assisting uploading all these documents.
Lordship, on a personal level, I have to agree with my lord, but unfortunately, as I submitted my lord, it's a mandate from the ministry. In fact, if Lordship looks at the portal, it is not our portal. It is a portal set up by the ministry where
There's no system for grievance redressal. Then what happened to her representation?
That is still
because somewhere CSA has seen that if you have any grievance.
Yes, ma'am. Yes, ma'am. So she has sent a representation. She has sent a representation that is on 27th of February. That is still with us, my lord. That is still with us.
Considered favorably. What is there?
Obviously, my lord, I cannot make a submission that it will be considered favorably. But if lordship allows us to consider it.
It should not come to outright rejection, because from the materials on record, everything's done bona fide. What submissions are made, writ petitions, just it's a lawyer's drafting. It's not really happened. Yes.
In fact, Your Lordship, on the 19th, that prior to the impugn order, Your Lordship, the petitioner herself has visited the office.
No, but he is saying that even if you go personally, also you have to come virtually. You can't go personally.
But in spite of that, Your Lordship,
documents.
They've issued this impugn order, Your Lordship.
Whatever it is, we'll decide it within 1 week.
Very well, madam. Very well.
And get back to the court.
Petition can be disposed of if they are aggrieved by that, whatever decision is made.
Yes, take down.
They have the liberty to come back, my lord.
The grievance of the writ petition, which has been brought before this court by way of the instant petition, is the rejection of her candidature, you say, or what do you say?
Candidature.
Rejection of candidature.
Candidature.
For appointment as a retail outlet. For appointment as a retail outlet dealer. Under the respondent number
2 and 3,
number 2 and 3. Stop. Next paragraph had been submitted by the counsel with the petitioner that on an advertisement on the, what is it called, a LOI or
advertisement?
And advertisement being floated, the petitioner had tendered her application, which was accepted, and in the course of the selection process, where's the order whereby you were said you be given the dealership? In the course of the process,
This
was selected.
Page 22, Your Lordship.
Was selected. After a draw of lots, and was accordingly informed by communication dated, this is on 29 December 2023.
29 December
It's,
2023.
Lordship, it's at page 19 actually.
23.
Which one?
Page 19 actually.
19.
19.
By communication dated
16th December.
16 December 2023. However, it is submitted that thereafter, due to some discrepancy, due to some defect in the documents uploaded, the petitioner, on being aware of the same, though belatedly, though within time, had attempted to upload the required documents, but was not successful. Thereafter, on being unsuccessful, the petitioner has submitted. It appears had even approached the respondents 2 and 3 physically with the documents which was not accepted, and has resulted in the rejection of a candidature presently by Annexure 10.
Annexure 10, madam.
On 23rd February 2024. Stop. Ms. S. Jindal, who is present on behalf of the respondents 2 and 3, has also submitted that the entire system being automated, the respondent 2 and 3 are not in a position to accept any physical documents, as the same is a directive of the ministry. He, however, submits that since the petitioner has preferred representation dated 27/02/2024, the same will be taken into consideration if any latitude can be granted, and the petitioner, since she was the successful applicant, be reconsidered. You are agreeable to that?
Yes, Your Lordship.
Yes. In this view, having heard the counsels for the petitioners and having examined the materials report, it appears that the entire it appears that the situation as has happened is because of the technical difficulties experienced by the petitioner, as also the fact that the same being managed through a dedicated portal, the notarized or the corrected documents could not be accepted by the respondents. Be that as it may, due to the fact that no malefides can be attributed to the action of the writ petitioner, the respondent is directed to dispose of the representation which has been filed within a period of 1 week?
2 weeks.
2 weeks from the date of receipt of the order.
Some interim protection will be given, Your Lordship. Some interim protection, Your Lordship. Pending disposal of the representation, no fresh advertisement.
Lordship, with all due respect, no case has been made out as yet.
Yes, pending disposal of representation, it is expected that the respondent will not settle the retail outlet with any other party.
Highly applied.
Disposal.
Day leaders, item number 1.
May I please, Madam? In this case, the brief story is that...
You're filing review for what, this one? Review is for?
That there is a mistake in the condonation petition which was filed in an environment. Date was mistaken. Instead of 28th March 2018, the date happened to be mistakenly written as 28th March 2017 for substitution petition.
365 days of your condonation application, you mean?
Yes, in the condonation
application. The earlier application, you said how many days delay is there?
1086.
And in this review, to review the order will come to how many days?
Quite a lot. I have not counted.
You have not counted.
No, the mistake actually, my lord, I have nothing else to say except ask pardon for the advertence on the part of the typist, then on the part of the counsels who did not go through the petition before signing, and because of the faith in the counsels, I had signed the petition without going through the date, whether it is correct or not. So the inadvertence
only
may
one
be pardoned.
mistake, Mr. Bora, if you recall, it's replete with mistake, the dates. One paragraph something else, another paragraph something else. And condonation of a period of so long, 1,086 days, that should be at least...
The ground of dismissal was that the date was mistaken in the environment.
Where's the order for dismissal? Where's the order? You're seeking review of? Where is it? Don't tell me you're annexed it. Is it annexed, Mr. Nongri?
Page 68.
It's annexed. Thankfully. Yes. 68. Yes.
My father, the original
in the order says it appears that one Reswal Tariang instituted a title suit with respect to a plot of land that he passed away on 27/6/2017. As per statement made para 2. Para 3 demonstrated the title suit was dismissed for default on 12/9/2017. However, para 4 demonstrated petitioners, a plaintiff's son, filed an application substitution on 23/17.
That was a mistake.
Now
My lord, the thing is that my father expired in June 2017. So I couldn't have applied for substitution 3 months before the death of my father. So 2017 is definitely a wrong date. That was mistake of the typist firstly, then the junior counsel who did not look at the mistake, then my mistake, the conducting counsel, and that was due to inadvertence, I must say.
No, for matters of condemnation, when the person, very important, be careful. You're a very senior lawyer. You don't, court can't...
Had the trust on the junior counsel.
Yes. So what do you want? You want to review this order?
Only that mistake be considered as, that date may be considered as 28/3/2018 and not 2017. And the condonation may kindly be granted.
You made such a long synopsis, but only for that one correction.
Yes, my lord. Only for that correction.
And you asked for condonation of 1,086 days also.
It happened because earlier I had gone to other forums also.
Lord,
Writ petition was also filed. Several cases were filed.
His application for condonation of delay for filing the CRP has been dismissed. It is on that, my lord, against that order which he has filed a review.
On that only. That mistake in the date.
Let's see the prayer. See, it doesn't see only for that date. You see, look at the prayer.
I'm slightly handicapped because I don't have a copy of the review.
You see the prayer. You also review impugn order rejecting your condonation application
on the basis of
the review. Okay, for that we can understand. But in the prayer you said review the impugn order dated 10/7/23, and before the please condone the delay of 1,086 days. How will the two prayers go on one? You review only with the early order rejecting your application condonation. If that's reviewed, then your condonation will be taken into consideration. One application you can't file it.
Yes, one of them, the first one may be granted.
How will you mold the relief? This is a civil revision matter. What to do? Okay, we'll allow your review. We'll permit you to file a fresh original application. Yes. For the ends of justice. Yes. This review application seeking review of order dated 10/7/2023. Mr. Bora submits that the petition is rejected in view of the incorrect dates that had been shown therein. So he prays that instead of the date appearing at where?
Para 3.
At para 3, it should read as 20th
para 4.
2018 instead of 17. Next para, the maintainability of the review application and the review also a review anyway. For the ends of justice, the review is allowed. Petitioners permitted, the impugn order is recalled. The petitioner is also permitted to file a fresh application for condonation. Yes, matter stands disposed of. And there's nothing to review. You can't review actually, but even then just...
Item number 2.
You file fresh application.
Please, Your Lordship. Lordship, the respondents are yet to file their affidavit, my lord.
Lordship, the affidavit is prepared. Lordship, it's ready. I just need some more time to file the affidavit.
Any urgency?
Yes, my lord, because the bank guarantee is going to be expired on 31st of this month, my lord.
You are the one who furnished bank guarantee?
Yes.
31st this month. You still have some time.
Lordship, 1 week's time, my lordship.
You're not here, you're not well.
Lordship, I had some problems with my lordship. I'm better now.
Right now, okay. What to do? 1 week's time.
1 week's time, lordship.
1 week's time, because on 31st it's expiring, my lord. It's difficult.
And then? What about number 3?
Lordship has already taken steps, my lord. I'm just awaiting the... Yes. No, already taken steps, my lord. We're just awaiting the service report, my lord.
Indicates that the AD card not been received back in respect to respondent number 3. Stop Mr. H. Karwanang for respondent 1 and 2 submits that praise that he will out for for the 1 week's time to affidavit.
Lordship.
Okay, prayers allowed list after 1 week for affidavit of the respondent 1 and 2 positively and for appearance of or for report on respondent number 3.
Lordship.
Who's respondent number 3?
It's a managing director, my lord. But it appears like other respondents have already received their the notice, my lord.
Lordship, as per the last order, the petitioner was supposed to file affidavit for status of...
They have already filed, my lord. So far as so far as 3 is concerned, it's still awaiting service report, my lord.
Item number 3.
Highly obliged.
Please, Your Lordship. Your Lordship, we're entering appearance on behalf
Why no
of...
appearance made by our chief secretary and
Your Lordship,
Why?
we're entering appearance on behalf of Respondent 2 and 3, Your Lordship. The Advocate General will be appearing in this matter, Your Lordship. We've already filed our affidavit also, Your Lordship.
where's the affidavit? You received it?
Yes, Your Lordship.
What
Your
does it
Lordship,
say?
as per the affidavit filed by the respondent number, the state respondent, Your Lordship, it appears there has been a change in officials, Your Lordship, with regards to respondent number 3, Your Lordship. So I require...
Number?
With regards to the respondent number 3, Your Lordship, there has been change in officials, Your
Number
Lordship.
three is whom?
The Secretary of DCA, Your Lordship.
Who said DCA now?
District Council Affairs. Now is Cyril, Your Lordship.
CV Lingdor.
So I require permission to amend the cause title, Your Lordship.
What about after respondent number 1?
Lordship, we'll be filing in a week.
Number 1?
Lordship, for 1. District Council.
He's Secretary's Council?
Yes, Your Lordship.
Committee.
Secretary of District Council.
Is she getting a salary?
No, Your Lordship.
She's not getting salary also?
Not the staff, not the MDCs.
And after it's been filed on behalf of the respondents, not state respondents, when you file after it should be right specifically on behalf of 1 and 2. And you have to state reasons why
2 and
1
3
and
are
2 are not appearing, why they're not swearing a personal affidavit. Because contempt is personal. Yes. MS Island has entered appeal on behalf of respondent 1 and
On behalf of the Advocate General, Your Lordship.
of Advocate General together with MS Island Y, they will be appearing on behalf of the respondent number
Respondent 2 and 3, Your Lordship.
2 and 3. Stop. She submits that an affidavit has been filed in this regard, or it's been filed with regard to the contempt application. So, Mr. Amanongpur, on behalf of one of the pays for
Your Lordship.
time to file affidavit.
If I may be allowed to change the cause title, Your Lordship.
Yes, 1 second, that'll come. 2 weeks time is permitted. Stop. Mr. P. Pasantev submits as he is now aware that the person's number 3, since it is a different person, may be allowed to implead the newly appointed, then the new person in charge of the office of number 3.
Obliged, Lordship.
Item number 4.
In this matter, we had filed a miscase 29 for impleading the KHDC in view of the rejoinder, in view of the affidavit filed by the Dorbashno.
Yes, so appearing KHDC.
Yes, I'm appearing for the KHDC.
It's already moved.
No, it's coming up for the first time.
Yes, Miss Case number 29/2024, in WPC number 295. This is application for completion of the Khasi Council party respondent number
3 apologies.
in the incident in the collected petition. Stop. State, who's for the state?
The state is not a party, only the KHDC.
I'm appearing for the respondent number 1 and 2.
The Varshnong Umpranai. You have no objection. Yes. What's your name?
A.K. Shilla. Army A.K. Shilla.
A.K. Shilla. Yes, A.K. Shilla Council. Next line. For the respondent number
1 and 2.
1 and 2. I have no objection. Accordingly, this case is allowed, and the KHD is implemented as participant number 3. Stop in the main case, and view the order pass in this case number so. KHDC to be added as a through whom? Through the secretary.
Through the secretary, executive
Through the
committee.
executive committee, we implemented as respondent number 3. Stop. The next order in the main case, Mr. Tito with so and so has since entered appearance on behalf of the newly implemented number 3. No further notice called for. When will you file affidavit?
My lord, I don't think we are required to file affidavit because there's no relief as such, prayed against us. The only thing is that, my lord, under the notification issued by the government, for implementation of the bylaws, it is the council now. For construction and all. I have a copy of the bylaws also.
They applied from.
So they applied from the Rambashnong. They had applied from the Rambashnong, who appears had given them permission on an earlier occasion, but subsequently he had cancelled it. No? Am I correct?
Yes. What? The Learned Senior Counsel, who is first one with 3, submits that the point in issue in the incident petition is regard to permission for building.
And electricity.
It's not really that. It's the issue now that has been raised by the respondents. If kindly, your lordships kindly have the affidavit which has been filed by the Dorbash now. That is what has occasioned the implement of the KHDC.
Yeah, what does it say?
Kindly have page 3 of their affidavit.
Yes.
Para 7.
Yes.
I just read that, Manoj. That the averments made in para 3 of the writ petition, that the answering respondent denied the same, and in reply it is stated that the alleged unregistered sale deed dated 9/12/2016 purportedly executed between so-and-so and the petitioner is denied, and the petitioner is required to be put to the strictest proof thereof. Notwithstanding, it is relevant to state herein that the concept of land transfer within the tribal areas is governed and followed as per the prevailing customary practice and tradition, where execution of any deeds with respect to transfer of ownership of a land, the same is executed in the presence of village head, that is headman Sordar of the particular village, which was duly recorded and entered in the office of the Dorbashnong as a matter of record. As such, till date the office of Umfadnai village and Dorbashnong, the alleged landed property...
Civil dispute.
What?
There's a civil dispute then?
No, my lords. We have a registered sale deed. It's not a civil dispute. This is not within the legislative domain of the KHDC. So therefore, by extension, the KHDC cannot say, or the Dorbar cannot say, that land transfer, for the purpose of land transfer, they have any authority whatsoever.
That means if you see the declaration, you have seen the declaration, but the registered sale is registered sale deed.
No, there is already a registered sale deed. They do not deny that. Can we also have page 4? The second paragraph in page 4.
But was this registered sale deed signed in the presence of the other
That's where the issue came up.
There are 2 sale deeds. One was executed before the Dorbar, and there is a registered sale deed, which is executed before the sub-registrar. Kindly have page 4, the second paragraph. That the said conduct and ill design of the petitioner was intentionally carried out due at the instant of Sri Don Boxar Walang due to well-known fact and instruction that the office of the answering respondent does not allow transfer of land either by way of sale, mortgage, etc. to a persons from outside the village without the prior consent and permission of the Dorbashnong.
Who is Don Boxar Walang?
He's the purchaser. He's the erstwhile owner of the property, the seller.
So what do you mean by instance of his instance that he wanted to?
No, what they're trying to say that Mr. Don Boxar Walang, who was the erstwhile owner of the property, has sold the property and violated the standing instruction of the village Dorbar.
No, what do you mean by this? By this sub paragraph? Said conduct ill design of the petitioner.
This is their affidavit, the respondent's affidavit.
Oh,
not my affidavit. We claim that we have duly purchased this property and we've had it registered. So the question that is raised is, does the Dorbashnong have any such power?
Now, NOC is obtained from whom?
We had applied for NOC from the Dorbar Strong. They've cancelled that. They initially granted it to us.
Where is that?
We have that. It's part of our writ petition.
In fact, my lord, they had filed a suit also.
We had filed a suit. That's time taking, my lord. So we withdrew it and we are before this honourable court.
Oh.
Page 12, page 79.
Page 79?
No, not of the writ petition, my lord. Not page 79, page 60.
55 is a copy of the suit.
55.
What happened to the suit?
We withdrew it.
Why withdrew? What were the prayers? What do you pray? What do you pray for there? 55.
The prayer is at page 62. If Lordships have it. My declaration as to right, title and interest. Declaration that the defendants, that's the respondents, do not have any authority to interfere, disturb, encroach or stop the plaintiff from further construction. And we sought compensation as well, an injunction.
So it goes beyond that. It's not a question of only, it's only question of building permission.
So they don't dispute my title. They simply said that the transfer is illegal.
The question
the transfer
here, my lord,
should have
is
been.
whether the issue here is whether the, permission of the Dorbar is mandatory. Your Lordship will recollect in 2014 an order was passed by this court de-recognizing the headman and the Dorbar
But that's been stated by the Supreme
Not
Court.
no.
They said they'll function as before. I mean,
Yes.
the order of
Then the
Supreme Court.
division bench, it went on appeal to the division bench. Now, in fact, the division bench made a slight error because they had directed the state government to frame rules in respect of the functioning of the Dorbar and the headman. Actually, it should have been the district council.
Yes.
This issue requires to be settled. This is
And every
happening.
ambition bill is stuck up.
Yes.
Yes. No, but the thing is that I think the Supreme Court says they'll function as before, correct?
Traditional functions.
Yes.
So what are traditional
that is-
functions?
That has to be
The
examined.
thing is that only that they feel that you've gone behind the back. That's the only thing.
Correct, they feel that. In fact, we've also said in our rejoinder they're willing to settle this matter with them amicably. We have no animosity with the village. We don't want any kind
Why
of.
don't you have mediation?
Let both the parties come before the district council, and as it is also, as I said, my lord, 21 notification says that the district council is the appropriate authority to grant permission for building and electricity and all that.
No, this goes beyond that. This touches a sensitivity.
Yes.
Correct.
You know,
It's more of a.
And my lords, to be very honest, we don't want to open any can of worms. We want to live there peacefully. We have a sale deed. They should just simply recognize the sale deed and allow us to make our construction.
It can be sent for mediation, my lord.
You don't know. You take instructions. Very open for mediation or not. I'm not sure though. No, submits that not one of the. It appears that in the next paragraph, from examination of the materials and on hearing the parties, it appears that the issue concerns the non-grant of NOC or the refusal and the withdrawal of the NOC granted to the petitioner to construct a dwelling in the village. And as seen from the affidavit, is due to the fact that the entire transfer of the said property was without the knowledge of the local darbar. Stop. It is also seen that the petitioner had on an earlier occasion filed a title suit which has since been withdrawn, and this application has been filed before this court. Next paragraph. Considering that a fact concerns a community and a person who's seeking to build a house within the village, the parties are directed to obtain instructions as to whether they would be open to mediation or to work with amicable solution, either before district council or before trained mediator.
And the parties can do it themselves. We can work it out with the lawyers itself.
Or if they could work out an out-of-court settlement. Yes. List after 3 weeks. You inform, we can work it out, then if we can settle it, why not?
Item number 5.
Lordship, here I am entering appearance for respondent number 5, Lordship. 3 weeks time may be given, Lordship.
By 3 weeks time?
3 weeks, Lordship. First appearance today, Lordship. I am entering my appearance today itself.
Yes, Mr. S. Sheikh, the independent behalf 105 today. And such service complete all respondents.
Yes, Lordship.
File affidavit.
Lordship, we need some time.
Mr. Anishulai appearing for 124. And similarly, Mr. Sheikh for 5. Please allowed 2 weeks time to file affidavit. Is thereafter.
Item number 6.
Also.
Lordship, the pleadings are complete. The matter may be listed for hearing.
You filed the agenda?
Yes, Lordship.
Mr. B. Deb submits joint has been filed. As the pleadings are complete, this matter for hearing usual course. After so and on so.
7.
May I please, Your Lordship, here petitioner, Your Lordship, no longer want to pursue in this matter, Your Lordship. So I pray I may be allowed to withdraw it.
Why? What's the matter about?
This is non-release of payment, Your Lordship, non-release of salary.
Mr. D. Nyota, the conservationer, submits that submits on instructions that the petitioner is not interested in pursuing the matter any longer. He praises him may be dismissed or withdrawn. Yes. May not be withdrawn. Yes, I'm hearing a court on the prayer also. Prayers allowed, matter stands closed or withdrawn.
All right.
Item number 8.
So, Lordship, I need some time to file my rejoinder.
How many times you asked for Jabran?
The second time.
Second time? 2 weeks further time.
In the meantime, Your Lordship, in this case, they have impleaded 5, 6, and 7 by name, Your Lordship. So we pray that they may be struck off from this because
So, Lordship, this,
there was
let me file
nothing malafide or anything done by them.
Five, 6, 7.
5, 6, 7.
Who's 5, 6, 7? Abhishek Goda.
Abhishek Goda, he is the subdivisional officer supply of Dadingri. And he's already been transferred. And he's already been transferred from Dadingri.
I make the party by name due to this, Your Lordship. There is lots of anomalies in the distributional rice. So,
That is not true, Your Lordship.
Your Lordship, this is true fact, Your Lordship. When in the agenda it will come up. And
We'll have the agenda file. If we will have we'll see if there are any materials against them, then they'll be asked to file personal affidavits. If not, be struck off. And you pay some cost.
Because food grains are being supplied regularly, there's no interruption or disturbance in that.
they have started now.
If there are no materials, you can't just allege malafide just like that. If there maybe you have apprehension or maybe there's some materials, that's to be examined also, whether any malafide can be attributed to these respondents. But if just for the sake of of alleging malafide and putting them by name, that's the thing. Because
let me file my
5 is no longer posted
Okay,
in this place. He's already been transferred. 6 and 7 is...
wait for the time being.
Okay.
So they're not placed on the lot 1 week stand for the joinder.
Maybe 3 weeks, Your Lordship. 3 weeks.
3 weeks for the joinder. Why? Okay, 10 days. 2 weeks, okay.
I'll keep the file.
9.
9 also same, Your Lordship.
Similar matter.
10.
Lordship, I've received instructions from the respondent to appear in this matter. I'll be filing my power today, Your Lordship. Because
What's the contempt about?
this is regarding the job card, Your Lordship. And that as the village, we are deprived
Who are
from
you?
that. I'm the Sardar, Your Lordship.
What have you done?
Lordship, this is nothing on record. There's no contempt actually, Your Lordship. Lordship, this is the second contempt that filed, Lordship.
See. Now see the order dated 22/2024. You read it.
Lordship.
You read the order dated 20th February 2025 by this court. This is a more serious matter because this only why contempt is not initiated against you now. You file affidavit, otherwise why are you depriving them?
I'll file my affidavit.
They said they've approached you and otherwise you have to appear personally next date.
Lordship, there's no document on record to show that they have approached us. And we're still waiting for them, Your Lordship. And as per the letter issued by the BDO, Your Lordship, they were supposed to approach us with their
But is
epic
it they've
card
come?
and everything.
Where you said that? MS Wanyang in your petition?
Lordship, they have annexed. Can you come to page 43? 43. They have intimated this Honorable Court order by. They have sent this letter by registered post, Your Lordship. Can you see the next page, page 44? That is the postal receipt.
See, they sent it to you. You received it.
Lordship, can you come to the next page, page 44? This is a postal receipt, Lordship.
Why? Where does the receipt have to personally go?
Lordship, we have not received this letter, Lordship. We have
You're
never
supposed
received
to comply with the order.
We
You,
comply.
you know the knowledge of the order, correct?
Lordship, we'll comply the order, Lordship. We are complying the order, Lordship, but they are not coming forward, Your Lordship. Lordship, their matter can be resolved, Your Lordship. Only they have to come forward and submit their necessary documents before us.
Do one thing. Where's your petitioner?
And Lordship, the petitioner is not even in the village, Your Lordship. She's staying somewhere else.
He's staying in the village or where is he staying?
They're seeing the village, Your Lordship.
So far as Lordship, I'll find my affidavit in.
No, let you appear in person. Let them appear also. Will you come to court? Will they come to court?
I think I need to obtain instruction, Your Lordship.
Lordship, let me find my affidavit.
Otherwise, if this is a blatant contempt, if you're treating villages this way, the orders of the court again, if they've gone and you're not giving them, what's preventing you? Why can't you reach out to them? Why should they have
Lordship,
to come
they are
and?
never in the village, Your Lordship. They're not stationed in the village.
You file affidavit, then
I'll
within
file my
1 week.
affidavit, Lordship.
Yes, Mr. Emal Nampur, appearance for number 1. He prays for 1 week's time to file affidavit. It's expected next year the affidavit should be on board positively.
Lordship, highly obliged.
You find out whether it's staying in the village or not.
11.
Obliged.
My lord, this matter pertains to the water connections, my lord. And
we are waiting for the instruction, my lord. We need some more time for the instruction.
my lord, may I draw my lord's...
No, yes, you remember, you're drawing all the water by yourself, Mr. You've been
No, my
depriving
lord.
other villagers.
Some disputes, my lord. Disputed questions.
Not disputed questions, my lord. My lord, may kindly see may I just draw my lord's attention to last day's order, 14th February 2024, 2024, my lord. At the second page, my lord has stated that the state respondent.
Yes.
State respondent shall try to resolve. Yes, my lord.
We have not received any instruction, my lord. We need some more time.
What do you mean have the instructions? Don't have them on telephone. Who's the officer in charge?
SDO PHE Sora, my lord. Because
was the order communicated to him?
Yes, already.
Received it. Who's the SDO? Which area is this?
Mausindram, my lord. It's Mausindram. SDO PHE Mausindram, my lord. So what I wanted to say, my lord, they are taking...
by last order dated so-and-so, this court had directed that notwithstanding the penalty of the petition, the state respondents were to try to resolve the dispute with regard to sharing of water. However, today Mr. Nsinkon has come forward and said no instructions have been received. The conduct of the concerned officer is not appreciated. An order of the court is to be acted upon immediately, and instructions, and immediately stop. Accordingly, yes? One second. Okay. With first, who's entering with whom? Number
5.
Who's number 5? Number 5, Food Funblay, and then you?
For respondent number 4, Your Lordship.
Chief. Yes, Mr. Pasa, correct? And Mr. Inombri have entered appeal on behalf of respondent 4 and 5 respectively, so such notice is complete. After that, yeah. Has come for a submitted note, has still been received. Yes, as it involves what essential commodity, essential, it involves water, which is essential for survival. Stop. It's expected next date that some action will be taken by the concerned respondents. Yes. Also, people will file affidavits. Respondents 4 and 5 also to file affidavits. It's a matter of water. You tell them,
My lord, there is a dispute between two.
There's a dispute, correct, but in interim won't be deprived. From what we can get is that he's depriving the other villagers, the other village, because they have larger numbers. So before they share the water, it happens everywhere.
Right.
Water is a scarce resource, and so they put in the pipes. They're drawing all the water, and now something has happened. Their pipes were ripped out. They've come. So they also must have done it because not getting water. So you should try to resolve that at least.
Item 12.
I'll correct the order later on. It doesn't mean that they. Yes.
Should we appear for the respondent's counsel?
Yes.
Appearing for respondent number.
What about 6 and 7?
Taken steps, Your Lordship. I've taken steps regarding.
Yes, office note indicates that ED card not received in respect of 6 and 7. Stop. Yes.
Lordship, this matter pertains to creation of the new village.
Yes.
Lordship, there's a statutory appeal available to the petitioner.
What's that? They didn't file an appeal?
They didn't file an appeal. I have no instructions, Your Lordship.
Then withdraw it. File an appeal if statutory appeal is there.
Lordship, this is second round of litigation.
Yeah, counsel, you should know where's the impugned order.
Impugned order will be at page 50.
Statutory appeal under which provision?
Under section 20 of the
Weighbridge
Act 2015. Lordship, I'm just appearing on behalf of Mr. J. Shalai, Your Lordship.
Yes?
I'm just appearing on behalf of Mr. J. Shalai.
It's very good. You take instruction on behalf of Judicial also. Yes, unfortunately indicates that notice not been served. Those reports available. It cannot receive respect 106 and 7 stuff. Mr. Ebal Nongpur appearing for the respondents number 125. Next paragraph has raised objections at the maintainability of the writ petition on account of the availability of statutory appeal, of a statutory appeal provision. Under what act is that called?
Giant Hills Autonomous.
Yes.
I'll provide that name of that.
You just provided. Yes. Mr. person next appearing on behalf of Mr. Jinshala, please will have to obtain instructions just after 1 week.
How do you oblige, Your Lordship?
Item 13.
Your Lordship, we had to file an affidavit. However, I'm seeking 3 weeks' time, Your Lordship, to file this.
3 weeks time, none appears as a petitioner. Respondent prays for about 3 weeks time to file affidavit just thereafter.
Supplementary list, item 5.
Yes, we're giving. Take a long time. After some time, we'll take it, Mr. Sen. Where's Advocate General?
He's having some personal difficulty, but if me, like my
So
senior
he'll
may...
finish his part.
Yes, I'll finish.
What
What my Advocate General said yesterday that he will make his reply
My
ultimately.
lord, will reply to the submissions on the next date.
Yes, no problem. I'll complete my note, almost complete.
14. Hearing 14.
Yang saat ni. One thing, where's Mr. Sen? I don't know. Where's Mr. How long will he take? No, we'll take that first then, if it is how long it is.
Okay.
It won't take long, this, because it's a part hurt matter. I got one. Because your matter will take some time also. You have to go through evidence. Yes. This one will take up, so it will take, because Mr. Majao said it will take half an hour. So we'll finish your matter first.
Yes. So, my lord, yesterday, my lord, we have referred to the affidavit, your lordship, referred to the affidavit filed in the first, not first, my lord, first round of litigation, that is the writ petition filed in the year 21. 3 writ petitions were filed, my lord, seeking a direction from this honorable court. A renewal was pending, and for a direction to the respondents to take appropriate decision.
Yes.
Now they filed an affidavit, that paragraph 5, my lord. Lordship, again, I am the cost of repetition. They said favorably. So actually, my lord, what I am submitting, a joint statement made by the secretary and the Commissioner of Transport, my lord. That was an affidavit by both, made a categorical statement favorably, my lord. That means they have taken a decision to settle it with me, subject to, but they said, my lord, as per Rule 7, and my lord, that is important, your lordships, I will take your lordship to that, policy decision of 2018. 2018 will take a decision. So my lord has disposed of the matter categorically on the basis of your lordship's statement made in paragraph 5. Disposed of the matter. And it contained, lordship's order contains certain directions. Lordship required the writ petitioner to file an application within 1 week, that is a direction. And then the respondent would expeditiously dispose of the matter, preferably within 1 month. So these are direction, your lordships. So ultimately, my lord, they acted on the basis of, they have repeatedly referred to the order of this honorable court, because that para 5 became a part of the order. And my lord, I will not go, yesterday I referred to that decisions, my lord, because if they had problem, my lord, they should have come and filed an application for expunging all those things. It never happened, it became final, become the part of the records. What is the evidentiary value, my lord, I am married. Now, my lord, in the circumstances, I will take my lord to the rules, my lord. Rules dealing with the settlement. Rules, my lord, I have annexed here. Rules, rule of 2009.
Rule number 8, correct?
Lordship.
This is number 8.
Yes.
Which page, the rule?
Page 29, madam. Now, my lord, for a second, if your lordship, if I can, my lord, this is a rule framed under, my lord, 138 of the Motor Vehicle Acts. Now, if I can take, my lord, that will be relevant. Definition of government, clause 2, page 30. Clause B, my lord. Government means Government of Meghalaya. So, my lord, this is why I am referring to this, because this is ultimately an agreement between Government of Meghalaya. It's not only confined to the Transport Department. What they say, Government of Meghalaya, and that all the, my lord, agreement has been made in the name of the governor. And they have referred that on government, referred to as Governor of Meghalaya, your lordships. Now, my lord, Commissioner of Transport, and then, your lordship, I will take to 3. It starts from 3. Installation of weighing devices. The government may install and maintain by itself as many weighbridges for the purpose of section 144, my lord, that should have been 114 actually, my lord, not 144, of the Act, on such places as it may think necessary, or may allow any private person, body person, company, organization to install and maintain such weighbridges on payment of lease amount to be determined in each cases by the government after calling tender. So, my lord, the word lease, my lord, occurred only in this, my lord, section 3 for the first time. Okay. So, it contemplated a situation either government of its own or through a private party. If it is through a private party, my lord, the requirement is inviting tender, and then there has to be a lease agreement to be executed. Now, my lord, regarding how the lease agreement, who will execute the lease agreement, my lord, these rules are silent. Now, number 2, no weighbridge without permission. Private person, body of person, company, organization shall not be eligible for obtaining lease permission to run the weighbridge unless he has attained the age of 21 years and above, and he has made an application for grant writing to the Government Transport Department through the Commissioner of Transport, and shall state, now these are the requirements, my lord, A, B, C, D, E, F, my lord, I am not reading them, these are the requirements, he should fulfill this requirement. Now 5, my lord, is very important. Permission for weighbridge at the satisfaction of the Commissioner of Transport. Now, lordship will appreciate the role played by this office, Commissioner of Transport. Almost everything depends on him. In considering the grant of permission, the Commissioner of Transport should satisfy himself that the proposed place for installing and operation of the weighbridge on National Highway State Road should fulfill the following condition. The adequate parking space, levy facility so as not to cause problem to the traffic congestion. B, that it is maintained in the safe and appropriate manner. C, the proposed location is consistent with public safety. D, the provision of loading and access loading is available. So, my lord, what the rule required, this rule 5, that the commissioner had to certify that these conditions are fulfilled. So, once that is done, my lord, now 6, what the 6 say, Commissioner of Transport to forward the application to the Secretary Transport Department. After satisfying himself that the application is complete and meets the requirement as laid down in the aforesaid Rule 4 and 5, the Commissioner of Transport shall forward the application with all the required information to the Secretary Transport Department for issue of permission. Now, here, your lordships, I'll pause for a while, my lord. What it is saying, 6, saying once the application is complete in all respects, that means the condition laid down in 4 and 5, is satisfied, then it is to be sent. Now, my lord, what it means? That obviously, definitely means when the first settlement is made, when the tender is invited. These cannot apply rigorously in the matter of renewal, because all these conditions to be fulfilled, 4 and 5, is for initial settlement. And 6 is referring to 4 and 5. So, what permission has been contemplated here, my lord, with reference to 4 and 5, that is the first initial settlement after tender. Now, your lordship, I will come to 7. 7 deals with renewal. Renewal of permission. A permission referred to in Rule 6 above shall be renewable every 3 years, and no such permission shall be granted or renewal unless the proposal for the grant of renewal or permission, as the case may be, is accompanied by a certificate issued by the Inspector of Weights and Measures, Government of Meghalaya, as to the accuracy, correctness of the device. No, it's very clearly, categorically, whatever permission is granted, my lord, under Rule 6, that itself is renewable. No way it is saying, my lord, a fresh permission order has to be issued again. That is wrong. Secondly, your lordship, my lord, I have gone through entire rules. No way it says, my lord, there is a specific format in which a permission has to be granted. It is nothing like this, your lordship. Even if your lordship go into the first settlement they have made, they have never issued a separate order granting permission. It is the agreement which say, my lord, government has granted permission to set up. Now the question of, at the time of renewal, my lord, the question of setting up a fresh Weighbridge will not come, because Weighbridge is already there. Only the permission already granted, my lord, which is very categorically mentioned in first agreement, that is to be renewed. Now, my lord, if I, for time being, admittedly, my lord, the renewal permission, these are governed by these rules, and wherever the rules are silent, my lord, they have a policy decision of 2018. Well, sorry, my lord, so far that 2018 policy decision is concerned, my lord, I have placed on record in the other writ petition, in my rejoinder affidavit.
Those are 299. Okay. Rejoinder affidavit. Where is it?
That is, my lord, rejoinder affidavit filed on 29/23.
Yes.
Affidavit in replement.
This is the Meghalaya State policy.
Lordship. That is at page, my lord, Annexure 1, page 11. Lordship, and kindly come to, my lord, third subparagraph, page 11.
1 second.
Lordship. Third subparagraph, my lord.
1 second. This is in
I'll just say.
page 19 of rejoinder. You see 299. If the rules are there, what policy? What mean by policy?
No, I'll just come to that, my lord. Even in the affidavit, they made a statement as per the rules, because many aspects are not covered by the rules. Like who makes the agreement,
But
how
they can amend the rules. Why should they?
But they have not.
Why,
My lord.
why
The
they
fact
should
is
go
this,
with
that
policy?
is not done. The fact is it is not done, they are still following it. Now, the third paragraph, if I can read, in Meghalaya, the Weighbridges are operated by private parties on payment of annual lease as agreed between government and operators. The Commissioner of Transport floats tender for all Weighbridges, and the comparative statements along with the tender paper are sent to the government for selection from amongst the bidders. The Commissioner of Transport then signs the lease agreement. Now here categorically they are saying, but who did this?
Yes.
But this is not provided in the rules that he is authorized. With the successful bidder tenderer to operate the Weighbridge, the successful bidder tenderer will have to sign and furnish the indemnity bond, etc., etc. So, my lord, I want to bring it to the notice of your lordships. Now, rules are silent. What are the format of the agreement? Who will sign the agreement? But the policy.
What is this policy then?
My lord, because this policy decision came much after the rules. Rules
Why,
came in 2000.
why policy decision? The rules already there.
Well, my humble submission, my lord, that aspects, my lord, for clarity, where, my lord, the rule has not covered certain aspects, my lord.
Is a policy ever notified?
This has been notified, as your lordship. Yes. Orders by the governor, notification. This itself is a notification, my lord.
It will be in the nature of executive
Notification.
instructions.
Notification.
Yes.
Notification.
It will be in the nature of executive instructions.
Yes, execution.
Issued on the hand of the governor.
Yes, hand of the governor. But my lord, so far notification is concerned, it would have been bad had it been contrary to any of the rules. It is not
Correct.
contrary to any rules. It is only, my lord, supplementing, my lord, what is not provided in the rules.
Yes.
So in that way, my lord, it is causing no harm. It is only supplementing, my lord. It's not substituting anything provided in the rules. And they made a statement in that affidavit. They will go by rules and the policy decision. What is that clause, they said, in the affidavit regarding this policy decision?
So you want to show the policy, the Commissioner of Transport
He
is
signs.
signatory.
He signs. So he is the authority, my lord, on behalf of the, not on behalf of the transport government, in the name of the governor, on behalf of the government of Meghalaya. 5. That affidavit. Page 56, my lord, I'm just coming to it. They have referred to, my lord, the operation Weighbridge to, and point number 2.3 of Meghalaya State Policy for Weighbridges 2018. 2.3, I'll just read, my lord, what is this 2.3? That is at page 14 of this rejoinder. At page 14, my lord, clause 3, under paragraph 2, enforcement of Weighbridge rule. The government of Meghalaya in the transport department shall ensure that all weighbridges are governed by the Weighbridge rules and the weighbridge operator abide by the said rules and also strictly adhere to the terms and conditions laid down in the lease agreement. The lease contract shall be for initial period of 3 years, which can be renewed on fulfillment of the requirement.
Why? This is the same policy which is type
Same
copy.
same policy at
But
14.
the numbers are not here.
My lord.
In the policy, in your type copy is not here, the numbers. It's here.
It is here, sorry, your lordship. Sorry. Oh, sorry, my lord.
Just, you're reading, just read from the
My lord, 22.
relay copy.
22, your lordship. Relevant part is, my lord, 23.
Yes.
23.
Well, it's clearer.
Enforcement of Weighbridge. The government of Meghalaya in transport department shall ensure that all weighbridges are governed in the Weighbridge rules and that the weighbridge operators abide by the said rules and also strictly adhere to the terms and conditions as laid down in the lease agreement. The lease contract shall be for an initial period of 3 years, which can be renewed on fulfillment of requirement as per the lease agreement. The licensee shall pay the government the agreed lease amount in 3 monthly installments, 7 days every month following the day, etc. So it speaks about renewal, my lord, how it is to be done, and how what are the mood payment, what are the number of installments, your lordship. So, my lord, they made a statement they will go as per the rules. And my humble submission, my lord, they have done it, my lord, following the requirement laid down in the rules and the policy decisions. Now, my lord, I have taken your lordship, my lord, how they have, after the order passed by this honorable court, that is at page 61, Annex 10 of the writ petition, your lordship, the process was initiated by the Commissioner of Transport.
Page?
Page 61, my lord, Annex 10.
Yes.
My lord. The process was initiated, my lord, relying on the order passed by my lords, and this was forwarded to the Transport Department. Kindly, your lordship will see, my lord, in the bottom. The Deputy Secretary, Government of Meghalaya Transport Department, for favor of your considerations. And otherwise, in the, my lord, body also, they say that this has been sent to the Transport Departments.
Where is consideration for information?
It's for information.
Copy two, yes.
For information. So this was placed before the Transport Department, which is otherwise, my lord, initial permission has to come from the Secretary. Now, my lord, thereafter, what happened, your lordships? Ultimately, my lord, at page 64, Annex 12, my lord, the agreement was executed.
The second agreement.
The second agreement, my lord, on the basis of which, my lord, I am claiming that I am entitled to continue. Now, here also, my lord, the recitation, my lord, I have taken, my lord, it is in the name of the Governor of Meghalaya, represented by the Commissioner of Transport, Meghalaya, Shillong, hereinafter referred to as government. So this is not a, my lord, agreement between the Transport Department and this person, between the Government of Meghalaya and the private lessee. Now, my lord, admittedly, this, my lord, they have categorically mentioned in page 67, my lord, the duration of the lease. At page 67, my lord, that it would commence from 1st June 2022 and shall remain valid till 31st May 2025. So after execution, I started working. Then came that impugned order, your lordships. Now the impugned order, my lord, nowhere it says, my lord, that there was no permission. Now, my lord, here I will, my lord, point out one thing, your lordship. Lordship has passed an order on the basis of the affidavit filed by them. Now that order was...
You're saying again and again, but the thing is that again the court on the last occasion was that the directions contained order did not say that settle the Weighbridge with you.
Exactly.
You don't renew.
Right.
It's just for consideration that since they have made a statement that they were reconsidering the renewal, so fine.
Right.
You also should be considered.
Right.
But does not mean to say that on the directions and pursuant to order of the court, you have been renewed. That is not there.
My lord, that language I have seen, my lord. But the fact is this, my lord, lordship has
Well,
because
in fact, we have to satisfy the court that it is, there was the orders. The thing is that there was substantive compliance, there was a consideration, and the renewal was given.
Exactly, my lord.
That's
And
what
there was, my lord, approval of the competent authority.
Yes, the competent
because
authority,
what they are saying that there is
due process was followed.
Exactly.
And you were given the renewal.
Exactly.
Which, however, they seek to water down now by removing the
enforcement officials.
And the impact of the impact is that the impugn order which has been recalled.
Lordship. No matter what remains, my lord. The moment it is withdrawn, these agreements come into force.
Then it comes with specific performance of this
no,
contract.
that will not come. That what I will rely. That what I will, because this is a statutory #1 contract. It is in the name of the governor, on behalf of the state. One of the parties is the state. Now, this law has been, my lord, very categorical. Normally, when there is a dispute with regard to a particular clause, the court may say it belongs to the private domain, go for specific performance or claim damages. But here is a case, my lord, what Tata Cellular, that law has not been diluted. Now, categorically, my lord, they have given a list when the court can exercise the power of judicial review. One of the reason they have cited, my lord, is reasonableness. Now, here what happened, your lordship? Impugn order was withdrawn, enforcement officials were taken away. The moment impugn order was withdrawn, my lord, this agreement come into force. Is it not unreasonable? That is most shocking thing, my lord.
Does it mean that your waiver slip is not recognized any longer?
Obviously, my lord, it's not functional, my lord. I cannot function as per the agreement and what remains. They have not issued any formal order. So if it is very unreasonable, my lord, the question of specific performance, sending me to a civil court will not come. And it is unreasonable, your lordship. Now, there in the Tata Cellular, they have discussed in details Wednesbury's principle of reasonableness and all. What is very shocking to a ordinary man, average man, your lordship. This is very shocking. Now, your lordships, now they are saying not permission. Now, this has been processed, sent to the Transport Department. Now, your lordship, kindly, in this case, I have filed a rejoinder affidavit. In this case, man, 2000, that 8. And page. My lord, will kindly come to page 10. The type copy is at page 11, your lordship.
Page the rejoinder affidavit.
Yes, my lord, my rejoinder affidavit, 11. That is dated 11 May 2022. So, your lordship, Under Secretary to the Government of Meghalaya Transport Department, it's from the Transport Department, addressed to the Commissioner of Transport. Sir, I am directed to forward here with a copy of the letter number dated such and such, along with enclosure received from the Government Advocate, Meghalaya High Court, Shillong, which is self-explanatory, and request to take necessary action. Necessary action. Necessary action, obviously they were a direction to initiate certain actions, as per the order of the Honorable High Court. And then they say, these has the approval of the competent authority, my lord. What remains? Even if assuming, my lord, that there should be some kind of approval, right, required, my lord, these convey in volume, my lord. They are saying it has the approval of the competent authority. The secretary was a party there, and he filed an affidavit, made a statement that we are favorably considering. So, my lord, where is the question now? What they are saying that there is no permission. Now, here one more thing, your lordship. This lordship order was passed. When this order was passed? No, not Sales, that 21. My lord, that order was passed by your lordship. Huh? 19. Each? 59. Lordship has passed that order on that is passed on 9/5/2022. Now, lordship has said expeditiously within 1 month on the date of the receipts. Now, what happened, my lords? They have taken some kind of decision. I have placed before your lordships, made the settlement with me, renewed my agreement. And when this impugned order was issued, they could have done, suppose, my lord, they do not want to renew it for reasons. Within 1 month, they should have taken a decision. And suppose it was their case that, yes, within 1 month, the direction was given to us. The direction was not given to the commissioner and secretary, commissioner of transport only. The secretary was a party, direction was to all the respondents. So they were under obligation to act. Now, if their case was that during this period we had taken a decision, permission was refused. But even then the commissioner went ahead and made this. I understand, my lord. It's not the case. They were fully aware about it. They have conveyed the approval of the government, and then the agreement was executed. After the execution of the agreement, my lord, in 2022, after almost a year, they have issued an impugned order saying, without citing any reason, that your agreement, extension of agreement is only up to September 2023. And I came before this honorable court. Now, your lordships, my lord, in the first writ petition, your lordships, no,
The
first
first
writ,
or second one?
First, my lord, first writ petition,
Wait,
your
three
lordship.
together?
Yeah, my lord. First writ petition, which is before your lordship also today, 299. Now, my lord has passed an order after looking into the order passed by the Commissioner of Transport, initiating the process for settlement, because he had referred to certain letters. So, lordship had called for those records. So, before these records were passed, my lord, they had withdrawn. The matter ended actually.
Given on official, those letters asked.
No, that's why I'll go into it. Well, they have annexed now. So,
They have annexed the affidavit.
they have annexed.
Okay.
Now, my lord, those were never produced. Now, in this case, my lord, they have filed an affidavit and they have annexed those letters. Now, what are those letters, your lordship? Where is this? It's not from.
In the
Where is
affidavit.
our Weighbridge? For me. Lordship, so far our Weighbridge is concerned, my lord, that letter is 20, because there are 3 other Weighbridges, which also were, my lord, settled by the same process. 20, your lordship.
Excuse me.
Annexure 6.
Annexure?
No, Annexure 6.
Of
Their affidavit in opposition, my lord.
19 Annexure 5. Yes.
No, my lord. So this is concerning our Weighbridge, 11th May 2020. Now it comes from it's from its Commissioner of Transport. Now it is addressed again Under Secretary Government of Meghalaya Transport Department.
Yes.
Renewal of the license of the Weighbridge, Amsarin Weighbridge, such and such. In this connection, I have honored to inform you that the license is Department Docker of the Weighbridge, Amsarin expired on such and such. The licensee had moved the code for renewal, which was, however, not renewed till date. In this regard, therefore, the licensee moved the code and the matter was lying pending till date. In the meantime, the department has requisitioned the Weighbridge temporarily to ensure that there is no disruption or loss to the government revenue. Decision is taken in this. The Honorable High Court, in its judgment dated such as allowed the petitioner to move the government renewal within a week, which is to be processed by the department within a month. Copy of this. Now, here they are saying what lordship has directed to process, to consider, my lord. Then he says the licensee has moved the department for renewal of license by court order, which is enclosed in original. The government is required, accordingly, the approval is required to kindly accord approval for the renewal as per the court directions. No, no way is say the court has directed you government. Entire thing was placed before the transport department.
Last sentence.
My lord. Government is required to kindly accord approval. Now, lordship will see one thing in the rules: who process. Entire, my lord, things are processed by the Commissioner of Transport. He will have to record his satisfaction. Then he will have to place it before the Transport Department. So this was placed, he has processed it, he has said, what this is the order of the courts, my lord. Now, can the other side, now government say that the Commissioner of Transport has misled the Transport Department, my lord, higher officials? No, it was opened for them, they have looked into it, granted approval, my lord, which was conveyed, I have just read now. Now, can they say the Transport Department, Commissioner of Transport, my lord, misinterpreted? The entire record was before the, my lord, Transport Department. Transport Department do not, my lord, in the court's matter, do not, my lord, depend on the advice of the Commissioner of Transport.
Who's the Commissioner of Transport now? He's still there, the same person?
No, well, somebody is Mr. Kharmalki, I think. Mr. Kharmalki, H. Kharmalki. No, my lord, that will be very absurd submission that the Commissioner of Transport give a wrong advice. It was open for the government, my lord. If they have any other plan, they could have approached the Advocate General for necessary clarification.
Okay,
They have never done.
they're finished with that. Now what's the next point?
No, my lord, next point, my lord, which I was relying. Now, they are saying all these things. Now, has the impugned order, which was ultimately withdrawn, has they cited, my lord, this is the reason for which, my lord, they have truncated the period from 25 to 23?
No reason ascribed.
Yes. Have they cited? They have not cited any reason.
Ascribed the affidavit not. See, the thing is that they're not saying it's like a gentle termination. It is not a abrupt termination of your agreement. The thing is that they've just made such a way that is unworkable.
Exactly, same thing.
That is what.
Same. I don't know, my lord. Because if your lordship recollect one thing, even when I was pressing for the interim order, my lord, they appear and they say, why? This should not have been, matter has been pending, it should have been decided. Why they have withdrawn? So even they admit, my lord, it's wrong. This is totally wrong, my lord, that too without citing any reason. And once you have withdrawn it, my lord, you should have allowed me to work. I have hardly, I think, another 14 months left, so far this agreement is concerned. Hardly another 14 months. Hardly 14 months left.
No, not the time.
Now, my lord, the question, next, my lord, what I will try to impress upon your lordships, the natural justice. Now, my lord, any kind of benefits, my lord, benefits conferred by an order, my lord, if it is sought to be cancelled, can it be done, my lord, without affording an opportunity of hearing? I will just rely on one decision on this, my lord.
Yes, that's a valid point.
Cannot be, my lord. On that count, it goes.
No, you see, that is one part. You see, the thing is that now, apart from the withdrawal of the enforcement staff to run the Weighbridge, so on and so forth, making it to dislocate the whole functioning. The only thing is that now, if you can show that how arbitrary was the action of the, that is a very important plank.
Yes.
The arbitrariness of the action, that's all, which resulted in violating your rights, whatever agreement you have. Because otherwise, we are transgressing to the realm of private commercial law. We don't want that. Like that, if your case is directed against that arbitrary action. That is
arbitrary and
it's like judicial review, administrative action. It's not specifically for enforcement of the. It's not for specific performance of the contract.
I cannot ask.
You're not asking for that. What you're asking is for like what is the decision-making process that has resulted in your in your agreement being sort of diluted and nullified. Yes. Yes.
Now, what
do you have natural justice? Let's see.
My lord, this principle of natural, there are hundreds of decisions. I will not trouble. Only one recent decision, 2023 6 SSC, page 1. Paragraph? 36. Paragraph 36, my lord.
Page 1?
Page 1. 2023 6 SSC, page 1.
Yes.
Well, just read it, man.
Para?
Para 36.
36.
Yes, man. If you can read it,
Yes.
Audi alteram partem rules, we need to bear in mind that the principles of natural justice are not mere legal formalities. They constitute substantive obligations that need to be followed by decision-making and adjudicating authorities. The principle of natural justice act as a guarantee against arbitrary action, both in terms of procedure and substance, by judicial, quasi-judicial, and administrative authorities. Two fundamental principles of natural justice are entrenched in Indian jurisprudence. One, nemo judex in causa sua, which means that no person be judged in their own cause. And two, audi alteram partem, which means that a person affected by administrative, judicial, or quasi-judicial action must be heard before a decision is taken. The court generally favor interpretation of statutory provision consistent within the principle of natural justice, because it is presumed that the statutory authorities do not intend to contravene fundamental rights. Application of the said principle depends on the facts and circumstances of the case, express language, and the basic scheme of the statute under which the administrative power is exercised, the nature and the purpose of which the power is conferred, and the final effect of the exercise of that power. So, my lord, here is very clear and categorical how it should have been done. But now here, my lord, number one, not even reason has been cited. Now, no permission, other things. Now they are saying, and now how they are saying, because on the very first day, lordship has expressed some reservation, how you have misinterpreted. Now in their affidavit, my lord, they have taken the cue from the courts. Now they made a lot of statements. But my lord, unfortunately, my lord, they have not annexed a single notings from the file or any single communication which says the government has taken notice. The commissioner and secretary made an agreement without the approval of the authority. He should have annexed. And I am confident, my lord, as on date, my lord, there is nothing on records, my lord. This is the reason for passing the impugn order. Now here, your lordship also, I will rely, my lord, when an order is challenged before the court, my lord, how it is to be examined. That is a constitutional van judgment. Then give. There is a gill. Page. There is, my lord, 1978, 1 SSC, page 405. Paragraph 8.
The Manderson Gill is it's
well, generally. So far 8 is concerned, is generally, my lord.
What is show para 8?
Para 8. Lordship has got it.
Yes.
I'll just read it. The second equally relevant matter is that when a statutory functionary make an order based on certain grounds, its validity must be judged by the reason so mentioned and cannot be supplemented by fresh reason in the shape of affidavit or otherwise. Otherwise, an order bad in the beginning may, by the time it comes to court on account of challenge, get validated by additional ground later brought out. You may draw the decision, earlier decisions. Exactly what is the decision? Have they cited that erroneously, without approval, this agreement was executed? So we are extending till this date. Have they, my lord? Have they issued a notice, my lord? Have they given me an opportunity? It should go on this count, your lordship. It should have gone. But, my lord, again, basically, I am arguing, my lord, assailing an impugn order which was impugned in the first round of litigation, which do not exist today, which had been withdrawn. My lord. This is a very unfortunate part, I don't know. Actually, I am not supposed to make submission on this. But I had to, my lord.
That is one.
That has been withdrawn, my lord. That impugn order is no more there.
That is why. Yes. That is why, Mr. Sen, the court is asking that issue natural justice with the larger perspective of the entire thing. It's a question of one impugn order has been withdrawn, correct? What should have happened with the? What should have been the consequence after withdrawal? What position would you have been in at that point of time? Now, the position of withdrawal impugned order, that means it reverts back to what it was before. And how circumstances has changed, and how it adversely affect you, and then why should you have been heard before this sort of other action was taken? Because it's not an action which is taken in it's nothing written. Nothing written. Only that those enforcement staff have been removed. So you have, as per the state, your Weighbridge is still existing. As per the state, that you can't run it. That's your bad luck. That is their stand. That's the only thing.
That is the stand. Yes. My submission to this is, moment it was withdrawn, and that also not for any other reason. They say pursuant to the order passed by these honourable courts. So they have taken notice of the proceeding pending before my lord, and the order passed by your lordship, and they had withdrawn. Now, what it mean, my lord, and convey? They had restored the agreement. There should not be any doubt.
We should go back to that. And what was...
My lord, that can be the only thing. They have referred to the writ petition, where it was under challenge. They have filed an affidavit.
Have you made pleadings in this writ petition to that effect?
What, my lord?
With regard to what will be, what would be restored? What should be restored?
My lord, definitely, that is my case, my lord. That is standard restored here. And so my prayer is also that. So I should continue as per that agreement. It's not a question, my lord, there is a dispute over some clauses. Then I understand.
No, you don't understand. What the court's trying to say is that they will say that nothing happened. There was an order you agree with, it's taken away. So you continue the order, the agreement.
No, then I'll take my lord. This
The only
agreement.
thing is that now by another decision, that since you're a private Weighbridge, now you're going to use our own Weighbridge.
No, my lord, cannot. Without cancellation, without giving me an opportunity. And that too a statutory contract made in the name of the governor. Article
Is there any
299.
order that says that your women's slip not be recognized anymore?
No, but nothing.
That's it.
No,
That's
no,
why it makes
nothing.
it more difficult.
No, that's where lordship. I'll take my lord to that agreement, that clause. Which is that clause?
I thought it took me half an hour now, already 1 hour.
No, my lord. This. My lord, in fact, I had taken your lordship yesterday. Page 74. Clause 19. It says the licensee shall issue receipt of payment fee to each good-laden vehicle signed by the driver, licensee, duly countersigned by the enforcement
yes.
inspector assistant. So, moment you withdraw, now I cannot perform. So, this is a writ court, my lord. It's court of equity also, good conscience also.
Of course.
My
Court
lord,
of
my lord,
balance.
what is happening? Even lordship understand what is happening. My lord, exercising
the
the
problem
writ
with kind of
power.
cases, Mr. Sen, with due respect to whatever the authorities that decide everything, is that even from the, from the genesis, and how it's progressed, they are seeking to, they feel correct something which has been unduly given to you, what I can understand. But the way they've gone about it, it has to meet the test of law, that's all.
Lordship. But then lordship will also see, was it given unduly to me? It is not given unduly to me. There was a approval. The matter was placed before the transport department.
Is that
Suppose there was
petition still available for consideration
That's
on the
what-
ground
that's
of,
what-
on the
my lord,
ground
no,
of
that's
because
what-
impede orders not
but
made
that is
anymore.
what the pleadings
So that
of
is
the
difficulty
Advocate
for the
General-
court
Advocate
also,
General is-
whether we can venture into that now.
Exactly. Should not, your lordship. Should not.
Maybe should not. It works to your advantage.
That's
but
why,
they
my
have-
lord, in the beginning I said, my lord, first writ petition has become infractuous. Moment they had withdrawn the impeding order.
But then, the facts behind it are very much. You live the veil.
That's
very
why I'm
much
making.
alive.
That's why I'm making. No, that's why I'm making. But this is not the reason. This is the reason, my lord. Court is drawing an inference. This is the reason, my lord, supplemented in a writ petition, which is
In
not
that
permissible.
inference, court just observed that the renewal was not pursuant to order of this court. It's just for consideration, and the order that's reflected in your renewal is that as per the order of the court, we're renewing you. As if there was no other
they have not said that as per the order we are renewing.
As if there was no other consideration of any other factors that would come to renewing. They said, as per order of the court, so you've done it. The only thing that a court says is that within such time, you take a call.
No, well, so far, what your lordship is a renewal as per the court's order. Perhaps, my lord, this word is not mentioned. You see, we need to take.
pursuant
No,
to order of the
what
court.
it said, need to take action as per the order of this honourable court. Now,
that also court.
No, well, that is depends how you. Now, lordship will appreciate one thing. I am a citizen, my lord, and I am against the matter. I am supposed to presume that things are correct, your lordships. And here it is not a case that the commissioner of transport, he has done everything of his own without information to the transport department. Then it would happen. If they had come, we do not know. No, it is not so. It was placed before the transport department. No, transport department secretary, commissioner, he cannot say. He himself made a statement before the court. We are doing it favorably. No, he cannot come and he is not saying. He is not saying, my lord, that we are not aware about it. And it will be very unfortunate to say, as commissioner and secretary, he did not understand the, my lord, meaning of, whatever has been directed in the judgment. That cannot be. It cannot be said that no.
Okay.
That will be very wrong, your lordship.
Anything else submit?
Yes, my lord. No, my lord, because I am going into it, because that is their pleading. Because now they are without permission. That's why I made a elaborate submission on permission.
It's like shifting sands anyway.
Now, my lord, they have elaborately referred to and quoted many paragraphs from a judgment of the, my lord, honorable, common high court pertaining to Meghalaya only. That is also relating to Weighbridge, Kamanlang Swayam versus State of Meghalaya. That is, my lord, 2011 SCC online.
In the affidavit?
In their affidavit, elaborately they have.
Where is that?
But they have raked up this issue. That's why I am answering.
Which?
The affidavit. Not only one, new affidavit, their affidavit.
Page number 4, my lord, of our affidavit.
This is the affidavit.
Okay, 5.
5. So, my lord, they have repeatedly referred to. Now, my lord, I have gone through that judgment. Well, I've gone through that judgment. But that the factual situation was totally different. There, what happened, my lord? There was some kind of agreement with the transport department, not with the government of India, with private parties. Now, there also there is a clause. There also there is a clause that after 3 years you can seek for renew, provided you file an applications.
Yes.
Now, my lord, what happened in those courts? They filed for a renewal. No, renewal was not considered. They, at a point of time, came before the court, somewhat similar here, my lord. Ultimately, government conveyed their decision that we will not renew. Renewal was rejected. And that has been categorically stated, your lordship. Background of the fact. Your lordship come to that judgment, my lord. Your lordship is holding that judgment. 2011, SSC Online, Guwahati 86.
You were there in the case?
No, I haven't.
Your name's here?
I was there, my lord. I was there.
With Mr. K. Parsaji? Yes.
Where am I?
Yes.
Oh, sorry, ma'am. Now, your lordship, if I can take to the facts of the case, my lord, the relevant part, your lordship, it may not tell you with my lord, under clause 10, my lord, Roman 10. This is Roman 10. Under the heading backgrounds of background facts.
Yes.
10, your lordship is on it. I just read. Unable to bear the inaction on part of the government in renewing the permission and also the agreement for lease, the writ petitioner preferred a writ petition under 226, which gave rise to WPC number 6759 of 2010. This writ petitioner was disposed on 5/12/2010 with a direction to the respondents to take appropriate decision on the petitioner application seeking renewal of lease agreement. Contrary to the petitioner expectation, the Secretary to the Government of Meghalaya Transport Department issued a communication on 17/12/2010 addressed to the petitioner, whereby the petitioner was informed that in view of the government's policy decision taken on 2/6/2010 for setting up integrated gates, Weighbridges, no extension in respect of the petitioner request for permission could be granted. So here, my lord, the renewal was refused. Or permission, whatever your lordship, or permission for renewal was refused. This is not the case here. Here is the case, my lord, a statement made, categorical statement made before the court, none other than even by the Secretary, who is the competent authority. It was
so
processed.
the thing is that what was prayed here is that renewal is by right, correct?
Correct.
But then renewal has to be as per permission, as per the rules.
Yes, obviously, this is not matter of right. This in court says that normally it should have been renewed. But when government has taken a decision because of the change policy decision, they will not renew. There is nothing wrong. Court did not entertain it. But here it is not. There is no change of policy decisions. Here it has been processed. It's not that behind the back. It was before the transport department executed. Okay. It's not that within the time limit they had taken a decision. We won't renew it. In spite of this, the transport department, I mean, commissioner has renewed. It is not the case. And even in the impugn order, my lord, they had not cited any reason. This is something, my lord, court is making the inquiry. Court is making the inquiry. And they have not placed even before your lordship, my lord, even a small communication or a document which say this is the reason. And my lord, I am confident, even on date, my lord, there is nothing on record that this is the reason why they have passed the imperial order, which was subsequently withdrawn. It is nothing, my lord. So my humble submission, my lord, these will not apply. They are referring to it repeatedly, my lord, this ratio, that was it altogether in a different factual situation.
Okay, what else?
No, my lord, regarding lordship has one thing in mind, my lord, two things possibly. One thing, my lord, lordship is making an inquiry. Initially it started like this. How it has been done? There was no direction from the court. Now that has been withdrawn. So my humble submission was the earlier petition became infructuous. Now, my lord, the state government, my lord, they have filed an affidavit. They rake up the same issues, my lord, which were involved in the first writ petition. They are saying no permission, etc., etc. Now, I have placed, my lord, before your lordships the facts. Now, other thing is concerned, my lord, some general statements were made regarding, my lord, enforcement of a contract. Now, but the law is very clear and categorical. When the contract belongs to the, my lord, purely in the private domain, your lordship, there is a dispute with regard to, my lord, enforcement of a clause or, my lord, not following the
statutory contract.
Statutory.
Under
My
the
lord,
rules.
here is two things, my lord. Once, admittedly, my lord, they have referred, yesterday I have taken my laws, they have referred to section 7. And even in this affidavit, they said we will do as per rule 7. So, my lord, there is no doubt, my lord, this is a statutory contract. And if it is a statutory contract, my lord, that is always enforceable. It is always enforceable. Court can, in exercise of judicial review, my lord, enforce it. Number 3, my next, my lord, in the context of, my lord, agreement, because
yes,
because, my lord, this is also an agreement, your lordship. One, I am saying it's a statutory agreement. Other thing I am saying, my lord, this is also an agreement, my lord, in pursuant to the power given to the state government to execute an agreement, my lord, under Article 299. Now, 299 is very categorically said, if it is by the state, in the name of the government. Now, recital, my lord, categorically say, in the name of the government, on behalf of the government of Meghalaya. So, this is obviously, my lord, also in exercise of 299, what the law says. Now, there also a sanction is required. That question came up before the Supreme Court. The sanction is required. The court said one agreement is executed in pursuant to the power of 299 by the authority, my lord. It is to be presumed, my lord, all kind of sanctions are there. It cannot be questions. What's that decision, Carol? Kashmir.
Anything else?
What else? Anything else? And my lord, in my prayer in the writ petition is, my lord, restore the enforcement. Number one, my lord, the way you have done so unreasonable. And second thing, my lord, the Weighbridge now overnight came up, my lord, the government of Weighbridge, just 2 kilometers away, my lord. That is with deliberate intention, my lord, to close down my Weighbridge. Now, your lordship, so far, my lord, the government in the year 2018.
Different places, one see as per a prayer.
No, lordship.
From Weighbridge to Amjeha.
This is just 2 kilometers. I made a statement. 2 kilometers. Just 2 kilometers from my Weighbridge.
That's
This
correct.
is nothing, my lord. No,
2 kilometers away.
Around 2 kilometers.
Now, my lord, how it has been done? Government has in fact notified the policy decision of the government to set up integrated check gate, my lord, that reached up to the Supreme Court. The Supreme Court declined to interfere, saying that it's a government policy decision. They can notify number. Now, in 2018, your lordship, they have notified the number of integrated check gates in different locations, different routes. Well, that I have annexed, my lord, page 49. That is dated, my lord, 30th November 2018 of my writ petition, your lordship, at serial number 2 for West Jantia Hills.
Which number?
Page number 49 of my writ petition, your lordship.
Yes.
That is dated 30th November. Lordship will kindly see.
So checkpoint only Amsarin. They can't have it anywhere.
Amsarin, checkpoint come, Weighbridge. Now in West Jantia Hills, 3 are there. Garampani, Mukhla. Now, where from this government Weighbridge, my lord, overnight comes? This is, my lord, only with an intention, my lord, to close down, nothing else. So, this action is not only unreasonable, arbitrary and malafide, my lord, it's only on sole intention to close down my affidavits in spite of them. So, my lord, this is a case, my lord, call for an interference, your lordships.
Okay. Yes.
And my lord, Tata Cellular, my lord, I will not trouble your lordship. Very category, unreasonable. Is it unreasonable? It's very unreasonable.
Yes, my lord.
And my lord, other thing, last one point, your lordships, legitimate expectation. No, what is the situation? There are a lot of decisions, I will not go. No, legitimate. No, things has a court, they came, made a statement before the court, we are doing it favorably. Then order has been passed, it has been processed, it has been placed before the department. No, department it was placed. All these are on records. And thereafter it was executed. No, what is the legitimate expectation of a citizen, my lord? He would run for that period. No, Honorable Supreme Court, my lord, has categorically said, if there is a legitimate expectation...
Part of the case of regarding, civil consequences and pecuniary loss.
Lordship, all these things are there. No, this legitimate expectation, when this legitimate expectations, my lord, is denied, my lord, that, my lord, by an arbitrary action, my lord, Supreme Court is saying, these infringe Article 14 of the Constitution,
Yes.
violates the fundamental rights.
Okay. Yes.
Yes,
Can you
my lord.
can you
Your
complete?
lordship, it will take time, my lord, because my friend has cited some judgments and all.
You reply.
Yes, my lord. I will start the reply, but it will take some time, my lord.
When can you do the reply?
Monday, your lordship may have it on Monday, my lord. I will whatever judgment has been cited by my friend.
Okay.
I will distribute those judgments also, my lord. And it's a court of records. At least something should be there in the pleading also, my lord. I have gone through the writ petition a number of times, and I don't see anything what has been argued before your lordship. That we will place all those aspects, my lord. It's a court of record which we, and the admittedly permission is also there. That has also been argued. Everything, I will place
You have
everything.
cited that 98-4 decision, correct? 409 regarding Court of Record.
I have cited.
Any pleadings there in the...
No, this is laws of legal submission. Why should I make pleading? This is something very
Pleadings, there are two grounds for that.
This is a law constitution law, my lord. 1-5.
Hearing 11.
My lord, only one small point I think we question. Your lordship asked me to clarify that one particular order was not under challenge. Let me finish it, since I have my lord. Give me that. That is your lordship. Impugn order.
The impugn order, see, the thing is that the clarification was the order you challenged
lordship
was in pursuant to some other decision where it truncated your whatever your agency.
Lordship.
Right?
Right.
And then they have put up a case that you have not challenged the mother order, only the...
in that order, in their order, they say this has been conveyed. Right, let me finish. This has been conveyed by government order dated. What is the date? Where is that order? Page?
And kindly see page 90 is also not under challenge. Page 90.
Lordship. Now, it say, my lord, the impugn order, my lord, which was ultimately withdrawn at 14 at annexure 80, page 85, my lord, it has referred to letter dated 26-23. Now, 26-23, this letter was never communicated to us.
Page
Number one.
90 is also not under
And that
challenge.
was for the first time, my lord, when your lordship was hearing the first petition, lordship wanted to know what is this.
Yes.
Lordship has asked him to produce. My lord, I was expecting at least in that order there should be some reason. That was produced before the court and I got a copy, first time.
Here,
Now, my
issue
lord,
is with-
I have brought
Page
this,
challenge.
now I have placed this, your lordship, by way of an affidavit. My lord, my reply affidavit, your lordship, at page 13.
2023 order is also
Page
not under
13.
challenge, my lord. Page 90. Page 90,
Lordship,
first
let
August.
me complete on this point, then you will get enough time, argue, my lord, answer all this.
I am
13,
waiting
annexure 2, page 13, my lord, of my reply.
Annexure?
Annexure 2, page 13 of my affidavit in reply.
Yes.
Now, my lord, lordship will see, this is from the Deputy Secretary, communicated to Commissioner of Transport. Now, my lord, it say, sir, I am directed to refer to your letter on the subject cited above and inform you that the government has conveyed its approval for extension of agreement up to 39/23 only and no more extension beyond that date. This has the approval of the competent authority. Now, here is the copy. Copy was never served on me, my lord. I got when your lordship has asked him to provide a copy. So, now, all these things, my lord, so far this is concerned, all these things stands withdrawn.
This order also stood withdrawn, my lord, by the Commissioner of Transport, my lord. My friend's argument, if I have understood correctly, government order has also been withdrawn by Transport
You
Commissioner.
reply.
I will reply. I will keep my powder.
Yes. Anyway.
I will keep my powder dry, my lord, for Monday.
14.
We came on adjourning this matter. How long will you take?
An hour. We have to take through all the evidences.
That's the problem. It's just any other short matter. This one will adjourn it. We'll have to adjourn it. Because evidence has to be gone into. And this is the first appeal, right?
First appeal.
And the court has to reappreciate the evidence also. When do you want it then?
May have it next week, Your Lordship.
Next week is a bit tight. You have to take it after 18th. This is after 2 weeks then. Give a date between 19th and take it, correct? We'll finish this off.
Bless you.
15.
Lordship,
yes.
Conducting counsel is on legs before
Who's conducting counsel?
My Lord, item 24 has to be decided first because the outcome from that writ petition has a bearing on this revision.
Item 24. How long will it take?
Well, this one's a revision, so it will take some time.
Which one? That's the second one?
This one. The other one's a writ petition.
Second one, let's see the writ petition.
That is the challenge made to the appointment of an acting lingdor.
You're the petitioner.
No, I'm the respondent. Respondent number 3.
Mr. Nongpure is in that writ petition.
Conducting counsel is on legs, Your Lordship, for the other.
Who? Dr. Mosika?
Yes, Your Lordship. Mr. Nongpure as well.
Is Dr. Mosika appearing this case?
Your Lordship, he's leading this in this matter.
Who's the petitioner originally? You were there?
No, I was not there. I'm doing the revision.
Why are you doing the other? In the writ petition, are you a party?
No.
Then why do you say it has to be decided first? What bearings does it have on your case?
This revision, in fact, this.
It can't be taken separately.
Against a lingdor.
A lingdor.
This is appointment of office, and this CRP is regarding land.
Yes.
Then why it has to be taken together? Why do you say that if writ petition is decided first has a bearing?
Is the nephew of the.
Who?
The present acting lingdor is the nephew of Mr. Bistam Agya. Now, Mr. Bistam Agya in this revision is the revision petitioner. So he will be fighting a case against his own nephew.
Is that correct?
Yes.
Tomorrow's course not here also. When should we have it then? Because this matter keeps on coming up and none of the counsels are available. It's been going on for a very, very long time.
If the petition is decided, then we can proceed with
Then we segregate it from the petition.
No, as and when it's decided, then this matter will be listed. That is the only way which.
That's correct.
Lordship, yes.
You come prepare writ petition then, after 1 week. This writ petition, this item number?
24.
24, yes, after 1 week, yes. Because this matter is, the counsels never appear, I've seen, in this matter. Correct? And then this other one, this is together, we'll see. As a counsel, as a leading counsel, in item 24, he stated we on legs, this matter after 1 week. Yes.
19.
Your Lordship, we have received an affidavit filed by the respondent NEPCO.
When?
On the 1st of March, Your Lordship. We require 2 weeks' time to seek instruction from our clients.
What affidavit do you file?
So, Your Lordship, that regarding the subsequent events that has taken place with...
What subsequent events took place?
That this matter is under negotiation before the Labour Commissioner.
Gotti, yes.
Labour Commissioner Gotti?
Yes.
Before the...
So, Your Lordship, I've been instructed by my senior counsel that there's some urgency in this matter. So if Your Lordship could take this matter after a week's time.
Okay, MS Karma submits that they have just been in receipt of an affidavit for which they need to seek instructions. This matter up to 1 week.
Much obliged.
20.
Yes.
Yeah, please, Your Lordship. White order dated 15/11/2023. Lordship was pleased to grant us, was allowed us to file this additional affidavit.
Yes.
This is already on board now, Your Lordship.
What does your lordship say?
Lordship, what has happened that day is I had pointed out that the petitioner's mother was receiving a monthly pension amount of rupees 21,389 rupees. Every month she is receiving this, and the terminal benefits also, Your Lordship, which she received was almost to the tune of 10 lakhs. So that was what I have brought on record, Your Lordship.
Then, what's the compassion ground?
Yes, Your Lordship.
Yes, Madam.
Yes, Mr.
Yes, Madam.
Yes. Yes.
So, Madam, we have to go through this scheme of compensation department to assess the situation, and as my friend has submitted about that so much money was given to her,
Yes.
that is irrelevant in the eyes of, if you go through this scheme, my lord, it is not at all relevant. So I will take you first, my lord, to page 12.
Awaited petition.
No, my lord, of the political opposition.
Of your?
Affidavit of...
No, affidavit in opposition, my lord, yes.
The respondent.
Page 12.
Yes, it is a letter to the principal director staff by the senior deputy accounting general, my lord. So I'm reading from 2, 3, 4, and 5 paragraphs. Details of the candidates for compensatory appointments, such as
Where are you
number
reading
of
from?
dependents.
Page 12, Your Lordship.
Page 12 is just...
Page 12 from second paragraph.
Okay. Yes. Yes.
Details of the candidate for compensatory appointments, such as number of dependent, assets, the liabilities, income of earning member, his liabilities, status of residence with family, and whether he should not be a source of support to other members of the family are to be considered. While item number 1 to 6 are objective, and information on which is annexed item 7 is subjective, and calls for an opinion on the basis of a statement of the candidate, the verification of the welfare officer, which also depends largely on the statement of the candidate and her family member, and the facts verified by this office. No medical (LTC) claims. Number 2, residence outside the state. It may be reasonably concluded that the earning member is not supporting the other members of his family. In view of the foregoing, the office recommends favorable consideration of the case. This issue with the approval of the Accountant General. Now, even the Accountant General has approved that petitioner is recommended for appointment. Then comes, my lord, to page 15.
Yes.
Page 50 also, it is a letter written by Senior Deputy Accountant General Administration to the Principal Director. At clause 12, below, my lord, last but one paragraph, clause 12, the DSC, means to say this screening committee, which met on 9/11/2017, after taking into consideration of all the factors, recommended that Ms. Lakshmi Joshi, that is the petitioner, be considered for compassionate appointment against the post of clerk, as there is one vacancy in the compassionate appointment quota. So this is the second recommendation, my lord, by the department itself. Then, my lord, third one is page 18. Page 18 is the scheme of appointment, my lord. It defines what is the meaning of dependent family member.
Yes.
Note 1 to clause B. Number 1 is object, my lord. Number 2, to whom applicable, and then there is applicable to A and B, and it is a note on A and B.
Note 1. Yes.
Number 1 is object. Number 2 is to whom.
Asking for the daughter of the deceased employee.
Yes, daughter, including adopted daughter.
That means C.
Yes.
Yes.
So now page 23 of the same scheme, my lord. Page 23. It speaks about the time limit for considering applications for compassionate appointment, my lord.
Yes.
So it says that prescribing time limit for considering the application for compassionate appointment has been reviewed by Department Order dated 26/7/2012, subject to availability of a vacancy and instructions on the subject issued by the department, and as amended from time to time. Any application for compassionate appointment is to be considered without any time limit and decision taken on merit in each case. So there is no time limit for consideration. Then, my lord, page 25, the same scheme. It's page 25, clause D, my lord.
Yes.
So recommendations of the committee should be placed before the competent authority for a decision. If the competent authority disagrees with the committee's recommendation, the case may be referred to the next higher authority for a decision. In my case, my lord, the recommendation of the Departmental Screening Committee was rejected. But nowhere in the affidavit it says whether it was referred to the higher committee or not. He has no authority just to reject it and it will be considered. It should be then referred to the higher committee or higher authority and let them take a decision. This was not done here.
Now, one thing, Mr. Sri, who was the earning member in your family?
The brother, the one of the son, your lordship.
Son is the, but for him also, yes, on two grounds my application was rejected, my lord.
Yes.
My lord, my application was rejected on two grounds.
Yes.
But page 47, section 9A of my writ petition, my lord.
Yes.
paragraph 3, my lord. This is a rejection letter, my lord. However, as there is an earning member in the family and your family is entitled to receive family pension at the enhanced rate till 11/2/24, and there are no liabilities in the family, the competent authority in headquarters office has not accorded approval for your appointment on compassionate ground. This is a letter addressed to the petitioner by Senior Deputy Accountant General Audit Fund. So these are the two grounds, that there is an earning member of the family, and number two, that the family is getting pension, my lord. On this, my lord, I want page 27, my lord.
Of your petition.
Yes, affidavit in opposition, my lord.
D.
36. C. Page 27, C. The scheme of compulsory appointment was conceived as far back as in 1958. Since then, a number of welfare measures have been introduced by the government, which have made a significant difference in the. I'm C. Page 27.
Page 27, Your Lordship.
An application
C.
appointment.
18C.
18.
18C.
Oh.
Page 27.
That paragraph C, Your Lordship.
C, yes.
13C or 18C?
18C.
18C.
Page 27 is different here.
Page 27.
Is it 27?
27.
It is a scheme, my lord.
Page
In
29,
internal
page
page
29
12.
in this application, in the court's copy.
Yes. So it is internal page 12, my lord. Scheme is internal page 12.
But as per the pagination is 29 here. Anyway, read it. What is this? Yes.
The scheme of compensatory appointment was conceived as far back as 1958. Since then, a number of welfare measures have been introduced by the government, which have made a significant difference in the financial position of the families. The government servants dying in harness or retired on medical ground. An application for compensatory appointment should, however, not be rejected merely on the ground that the family of the government servant has received the benefit under the various welfare scheme. While considering a request for appointment on compensatory ground, a balanced and objective assessment of the financial condition of the family has to be made, taking into account the asset and liabilities, including the benefits received under the various welfare scheme mentioned above, and all other relevant facts such as the presence of an earning member and size of the family, age of the children, and the essential needs of the family. So what I am stressing here is that any payment on account of any welfare scheme, this enhanced scheme, pension scheme, is a welfare scheme, my lord.
What
So
about
this
the
will
roster? You don't have a roster in your office.
Lordship, what has happened is every year in the month of April or May, Lordship, there's an assessment. So I just spoke to the office also this late evening yesterday. They said we'll see to it if there is any vacancy, which...
see, compassionate ground in every office, they have a...
There will be, sir.
Okay.
There will be, Your Lordship.
The thing is that, but as the time goes on, he died when, this person?
In the 11th February 2014. So it's almost
now,
for 10 years.
It's 10 years. Now the thing is that compassionate appointment is given when there's a dire need to avoid the family going to penury or to destitution or to be thrown on the street. And so that is why the longer your compassionate appointment application is pending, the lower you go in the roster. It's not a question that you applied first, you get first. It's as per as per the need. Suppose a person dies just a month ago, but the situation is such dire that the wife and the children are out on the street, then they will have a more priority over the early ones.
Very
Even
right.
though you survive over 10 years, you're getting pension, and also whether your case in fact doesn't become stronger over time, becomes weaker. That's one thing. But if there's some violation of some statutory rule or something, then that we can look under. Otherwise, 10 years compassionate ground.
10 years. I mean, to tide up that immediate relief, Lordship. That is very important.
Delay was caused by...
But my lord, the scheme says that time is not a consideration for a year.
Time is never consideration for considering anything. Okay, time of constitution or a factor, but it is looking into other other central government officers maintain a roster of there's a list. Suppose one year he might be number 10 for consideration.
Yes.
But next year you'll slip to number 15. Someone say, why have slipped number 15? But because other more deserving cases have come in between. That is what happens in compassionate ground.
Yes, Lordship. 5% always reserved for.
That is compassionate ground is not appointment
But
in due course
if
under
there
Article
is-
16 something. It's an appointment which is totally peculiar and different from the entire recruitment process. So that is why the parliaments are given a lot of play in the joints also were deciding these matters. Some have schemes, they go by the scheme. Yes.
So my point is, Lordship,
No, their point is that you're not now, after rejecting the compassionate ground, they have not put it before the other higher authority.
Yes, Lordship. That point number D. I've noted that, Lordship. So if your Lordship allows, then we'll do this. We'll refer this case to the higher authority and let's see.
How old is the petitioner now?
But after 10
Petitioner
years,
is around
after
30.
10 years, they will go out.
So after the enter service, they retire straight away.
29, 30.
No, Lordship,
Yes.
she's more.
Oh, sorry.
Rejection order is of 2018. They should have
36.
set it then and there.
36 in 2022, Your Lordship.
36, 37, 38.
She is unmarried.
She is married now.
Yes, sir.
And after marriage, also have to see the scheme if the scheme provides that to the married.
Scheme does not say whether married or unmarried.
I have just spoken to the. She is married. She is married. But the scheme does not provide either married or unmarried.
It provides that.
It provides, Lordship.
It provides for the immediate family to, know, that
See,
suppose
married-
the son or daughter gets compassionate ground can help the family. Not a question that you give compassionate ground to go and marry someone else. And
She has
still have a
married
family and
recently.
support some other family.
She married recently also because. And that also scheme does not provide that.
You can read something to the scheme. What does the scheme say? It does have to be black and
to
white.
meet the dire,
Just I think you can read down or you can read into also. See, now C14 then, page 10, internal page 10, page 14. Armed Forces.
They are dependent
What is this,
family.
what is this scheme? This is for
Scheme for companies.
central government.
Yes, Your Lordship. They have enclosed. We have also enclosed.
It's also there in the writ petition,
So why
Lordship.
Armed Forces?
No.
It's not for the armed forces, my lord.
C14.
Yes.
Okay, sorry.
Yes,
You remember Armed Forces? Yes.
This page 18, note 1, Your Lordship. Dependent family members means. Are you there, Lordship? Spouse or son, including adopted son, or daughter, including adopted daughter, or brother or sister, in case of unmarried government servant.
Here we are daughter.
Brother and sister will come only when the employee is an
Does not
unmarried person. This will not come here.
So, Lordship, in the scheme D also, as my senior has pointed out, the recommendation of the committee should be placed before the competent authority for the decision. If the competent authority disagrees with the committee recommendation, the case may be referred to the next higher authority for the decision.
Where are you reading?
This is page 25, internal page 10. As been pointed out by my learned senior here, Lordship. So if you allow me, I'll take this matter up to the higher authority. Because the only point my
After
contention...
10 years,
Whether marriage is permitted or not. We'll do some research on that.
Yes, Your Lordship, we'll do that, Your Lordship.
the ST is silent on that.
Even then,
Unlike
yes.
21.
well,
Highly obliged, Your Lordship.
Lordship, this matter, please come up next week, Lordship. Just try to dispose of next week.
One second. Oh yes, this case then.
It was heard last time,
You
Lord.
opted
It was
for,
heard last
you opted
time.
for the
For
promotion.
that promotion, yes.
So
opting for
you
that.
cannot, yes.
Lordship, can you just next week just finish it up?
You have no case then.
It was heard last
I'll try, Your Lordship.
Yes, I request to Councillor Parikh. This matter after 2 weeks take it because next week court won't be here.
Lordship.
Apply, Your Lord.
23.
Yes, what objection?
May I please, Your Lordship?
My Lord, this is a teacher matter, and on the...
So they told adjournment in the morning that you objecting was done by whom?
My Lord, it's by me, my Lord.
Why?
My Lord, here is a school, my Lord, is a teacher who has deserted since August 2015, my Lord. Now it's almost a decade, my Lord.
But who's the senior?
NSYNC on Your Lordship.
Where was he just now? He was here.
Due to some personal difficulty, he had
What
to...
difficulty? Suddenly he went outside and became personally very difficult to come back inside. Why he left the court?
And because of that, my Lord, we are not able to recruit a new teacher also, my Lord. Students are suffering, and on the last day, my Lord, on 8 February, Mr. Sinkon has undertakes to file rejoinder affidavit within 2 days. So the rejoinder have not come, so it has been closed. So therefore now, my Lord, in my humble submission, nothing left in this matter, my Lord. What happened was, my Lord, after August 2015, there were so many complaints against him, and as and when we were taking action against him, he keeps on approaching this court, my Lord. So finally what happened is that, my Lord has, with the permission of the court, we have appointed inquiry officer. Inquiry officer has very fairly conducted, and he has admitted to all the charges. He said that he deserted the school since August 2015. He said that he has, even though a deficit school teacher, he has drawn money under, he got enrolled himself as the beneficiaries under MG Rega scheme. And also, he also admitted that...
You call Mr. Sinkon.
He won't be available, Your Lordship.
Call him. You call him, he was here just now. You call him.
He is not in the premises, Your Lordship. He had to leave.
Let it come tomorrow then, my Lord, because...
Tomorrow this court's not here.
Tuesday then, my Lord.
Wednesday.
13.
Yes, this matter on 13 is a fixed matter.
My Lord. Obliged.
Chill to pencil hammer. Thank you.